make a
Yes,
mention,
please.
my lord. One TRP
For
matter.
listing.
For listing.
Listing old or fresh?
Fresh 2024 matter,
24.
my lord.
So after
I am-
notice.
After notice, my lord.
So give
I am
the
for the
memo.
opposite party, my lord.
Give the memo. Give the memo. There is a stay order.
Stay order is there since 26/11/24.
Okay. Give the memo.
My item 13, my lord.
1-3, sir. There.
13.
Achha.
13, my lord. It is come after vacation, my lord. I have taken
Which for the
consent
other
from
side?
the other side also.
The other side has to be present.
Hey, present, sir. Yes.
You are you, Mr. Bono Bihari Rai.
Yes, my lord.
Who is for the other side? Na, sir. ଆପଣଙ୍କ ନା?
इसके साहू
इसके साहू ତ ନାହାନ୍ତି ନା ଡିଏନ୍ ମହାପାତ୍ର
ପିକେ ମହାନ୍ତି ସିନିୟର
ପିକେ ମହାନ୍ତି ସିନିୟର କାଉନସିଲ appearing for କାହା ପାଇଁ appear କରୁଛନ୍ତି ପିକେ ମହାନ୍ତି ପୁରୀ municipality yes date ଦିଅନ୍ତୁ ଡେଟ୍ ଜଲ୍ଦି କରନ୍ତୁ
Item 23, my lord.
24/6
Item number 1, my lord.
Item 23, my lord.
23
Yes, my lord.
yes
I am appearing for the petitioner, my lord, wife of the opposite party, my lord. It is settled up in Jauchi. Let's we can take after vacation, my lord. Instruction
for the other side
other side me intimation कर देती phone रे कही
right don't make me party to this preemptive adjournment
Yes.
in absence of the other side and after notice matters fresh matter it ठीक अछि it is let it be noted I can note it down but it
Yes.
Item number
30 मिनट
ठीक है गोटे सरला परे ना
Item 1.
आइटम
आपन नाटा सर
SK पाड़ी सरोज कुमार पाड़ी
अच्छा अछि yes you other side की
other बाहाली BP बाहाली
सी आपन को तरह राजी अर्जन करे राजी हो जो
नहीं।
केस कहीं अपन तो
ମୁଁ transfer petition
केस
ମୁଁ
चली
125 transfer petition ଟା फाइल करछि एटा आउटा 13 ମୁଁ ତାଙ୍କୁ କହିଲି ସେଟଲ୍ ହବ ତ ସେଟଲ୍ ପାଇଁ ସେ ରାଜି
ସେ କେବେ ଚାହୁଁଛନ୍ତି
ଭ୍ୟାକେସନ
ଡେଟ୍ କରିଥାନ୍ତୁ if he objects it will not be
Yes,
adjourned
yes, ma'am.
that's the
Yes,
short
Item 1, my lord.
So I-
Item 1.
item 1 ଟିକେ ରୁହନ୍ତୁ call ହବ if you are in a hurry then or any other bench then
आइटम
Interested
30 मिनट
My lord, item 16.
1-6
16. After vacation, Lord senior is
Any day I am not objecting to, but let it be a final date now. We have taken umpteen number of times.
yes, my lord.
This is 20 years old matter. This is the
That's
second time of
that is
litigation.
true to 20 years old matters are being listed
20 years old matter,
Yes,
second
yes, madam.
time, for the second time.
7 years in this court when do you want Mr. Purohit and Mr. Nath
My lord. After vacation, any day, my lord.
any day nahi actually I have been searching for that any day
My lord, 21.
Eh?
June 21st.
Let him file the counter by.
Yes,
June
yes, my lord.
25.
Yes.
Case being listed 1 week after I filing the end of the.
June 21st ଆପଣ କୋଉଠୁ ପାଇଲେ any day ତ ନାହିଁ June 21st is Saturday
Sorry, my lord.
sorry my lord भी तो नहीं
June
not there.
24. June 24.
ये 24 कर दियो
My lord.
24/6
My lord, from the list.
ठीक है सर
आइटम 30 मिनट
24/6 on consent
आइटम 30 मिनट
yes
I am for the opposite party husband, my lord. I have taken consent for the petitioner, my lord. Mr. Ramesh Chandra Swain. I have taken up after vacation. my lord.
କୋଉଠି अच्छा नहीं ସେଇଟା ଆପଣ ତାଙ୍କ ପ୍ରେଜେନ୍ସ ରେ କରନ୍ତୁ
My lord,
ଆପଣଙ୍କ କେବେ ଚାହୁଁଛନ୍ତି
After
Miss
vacation.
Das
After vacation, my lord.
ଡେଟ୍ କରନ୍ତୁ
my lord, item number
Aye?
2.
2/7 if he objects then it will not be adjourned
My lord, item number 1 after vacation, my lord.
ଟିକେ ରୁହନ୍ତୁ ସର ଲିଷ୍ଟ କଲ୍ ହବ ଆପଣ ତ ମେନସନ କରିବା ପାଇଁ
My lord, item 18, my lord. For the petitioner, I have taken consent from the Union of India. My lord, he has also telephoned me to Arjun. He has some personal.
ତାଙ୍କ ନାଁ କଣ
Koivalya Panda.
ଡେଜିଗ୍ନେସନ CGC
Again. He has some personal difficulty. So, he has-
Mr. Sahoo
Yes.
SK Sahoo for PK Mahanti
Again.
yes କେବେ ଡେଟ୍ ଚାହୁଁଛନ୍ତି Mr. Sahoo
17 June.
after vacation ନା before vacation
After vacation.
ଡେଟ୍ ଦିଅନ୍ତୁ ଆଜ୍ଞା 2/7
My lord, item number 2, my lord.
ठीक है तू कॉल हବ ସାଙ୍ଗେ ସାଙ୍ଗେ କଲ୍ ହବ ତାପରେ ନେକ୍ସଟ
Item 17, my lord.
ସରି
38, madam, 38. After vacation, madam. State is other side.
38, how many times it has been listed before this match? এটা আগুর লিস্ট হইতে লাগে
Madam,
হ্যাঁ
other batch. After vacation.
38 এটা তো লিস্ট হয়নি কেবে চাହୁଛନ୍ତି মিস্টার পন্ডা
After vacation. After vacation.
ডেট কোন
30th June. We come in 30th.
yes next
My lord, item number 2, my lord.
ଟିକେ ରୁହନ୍ତୁ 2 ପାଇଁ ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି
Item 17, my lord.
17
My lord. On behalf of Mr. H.S. Mishra, kindly adjourn the matter, my lord.
ଆପଣଙ୍କ ନାଁଟା ସାର୍
Ambarish Mishra.
do you want
23rd June, my lord.
immediately after reopening that you leave that week করুন জলদি করুন 3 7 23
Obliged.
25 yes next
My lord, 2017 service matter, petitioner,
17 you want listing
my lord,
after notice matter
my lord.
give the memo before vacation you see how many working days are there today we are on 2nd so 5 plus 4 9 working days কাল তো ডিভিশন বেঞ্চ ଅଛି ବୋଧେ তাহলে ଯୋଉଟା କାଲି ପାଇଁ ତ କିଛି ମ୍ୟାଟର ଆର୍ଜନ ହେଇନି ডিভিশন বেঞ্চ any other mention call the list item 1
list. Item.
yes
Can it taken up after vacation, my lord?
you are Mr. Kamal
Yes, my lord.
Mr. Abes Kamal for the petitioner for state who is appearing Mr. Swain
Mr. Swain.
sorry
AGA Mr. Swain.
Mr. Sanjeev Swain AGA hybrid mode chalchi to hybrid mode likhibe the learned counsel for the petitioner seeks accommodation when do you want Mr. Kamal
After vacation, my lord.
the petitioner seeks adjournment to advance arguments as prayed for list code date karantu 3 7 20 25 yes
Item 2.
My lord, item 2, I'm praying for an adjournment. Kindly taken up after
Mr.
vacation.
your name sir
Abhijit Mahanti.
Mr. A Mahanti for the petitioner when do you want
My lord, after vacation, my lord, on
after vacation date karantu
2 sir.
the counsel for the petitioner seeks accommodation to advance arguments as prayed for list on 2 7 20 25 opposite party likhibe Mr. Sanjeev Swain AGA yes next
obliged, my
Item
lord.
3.
May I please, your lordships?
yes please
My lords, am I audible, my lords?
yes
My lords, Annex Year 3, the order passed under Section 45A of the SI Act is under challenge, which has been passed without affording opportunity of hearing to the petitioner. That is my simple grievance, my lord. Your lordship may kindly come to page 14.
Patila
Page, my lord.
actually the internet connection is unstable so please bear with that
No problem. My lord, sir.
is it available Mr. Mishra
My lord, it is available, but here,
Okay.
my lord, since there is no opportunity of hearing, my lord,
Right,
consider
right.
matter.
Mr. Somnath Mishra for the petitioner Mr.
Let them appear, your lordship will decide.
I will copy.
Mr.
I am appearing for SI corporation. If copy is
And
of
for the copy
Mr.
on Mr.
PK Rai
Tripathi.
AP Rai.
ND Tripathi.
AP
AP Rai on behalf of Mr. AP Rai.
you are Mr. Tripathi
Yes, ma'am.
DN
ND.
ND Tripathi Mr. ND Tripathi on behalf of PK Rai,
AP Rai,
AP Rai for the
ESI Corporation.
opposite party.
My lords, I'll serve a copy by
At learned
today.
counsel for the petitioner, it is submitted that the order impugned dated 13/12/2024 has been passed by the authority under section 45-A of the ESI Act 1948
Without affording.
without affording any opportunity of hearing to the petitioner. It is a company.
No, my it's a contractor. Contractor.
The petitioner who is a service provider contractor, labor contractor. How do
The contractor takes up this construction work and all that.
the petitioner who is a civil contractor taking up construction work?
Yes, ma'am.
This further submitted. On being asked, subpara, on being asked, the learned counsel for the petitioner submits that the order is appealable. However, in view of violation of principles of natural justice and the order having been passed without following due process of law, petitioner seeks intervention by the court in exercise of extraordinary writ jurisdiction.
Deeply obliged.
Issue notice along with this order. Mr. Tripathi, on behalf of Mr. Rai, submits that he has instructions to appear on behalf of the opposite party, ESI Corporation. How many copies, Mr. Tripathi?
No, my
One
lord.
copy.
One extra copy also.
One copy of the.
Two copies.
He has instructions to appear on behalf of the so and so, and waives notice. The learned counsel for the petitioner shall serve an extra copy of the petition on Mr. Tripathi during course of the day. Mr.
My
Mohanty.
lords, my lords. Yes, ma'am.
Mr. Somnath Misra along with Mr. Joseph Mohanty.
Obliged.
How much time, Mr. Tripathi?
4 weeks, my lord.
After
The
vacation.
counsel, for the opposite party, 4 weeks time to obtain instruction. As prayed for, list on 7/7/2025.
Next year, 3 may be state, my lords, or no coercive action till next year.
IA 6/1 of 2025. Had learned counsel for the petitioner. He reiterates his submissions as noted above. Issue notice. Mr. So-and-so, reproduce kar deve. So Tripathi on behalf of so-and-so appears and waives notice on behalf of the opposite party. Let one extra copy of the IA be served on Mr. Tripathi within 2 working days kar diyo. During course na kariki, there is like 2 working days kar diyo. As an interim measure, it is directed that the operation of the order impugned, the 13/12/2024, shall remain stayed till the next date of hearing.
Deeply obliged.
Liberty to mention for listing before the assigned bench.
No, your lordship fixed date to 7/7, na? Your lordship.
कितने तारीख को है? Yes, 7/7.
Again.
Yes.
Item 4.
My lord, I pray for after vacation, my lord. And
Mrs. P. Bastia,
yes, my lord. Within 7 days, I will file
for-
recuse, my lord.
for the petitioner.
Yes, my lord.
The matter has been listed for orders as the requisites for issuance of notice afresh. For notice to be issued afresh. Requisites for issuance of notice to be issued afresh has not been filed. The learned counsel for the petitioner seeks
Within
further
7
accommodation as prayed for. The requisites shall be filed within 7 days, 7 working days, fixing early returnable date. List after SR. List on kete karantu? 8/7/2025.
interim order. It is that, my lord.
30/8/2024 shall continue till 10 ଆପଣ କେତେ 8/7 କହିଲେ till 12/7/20 nahi, just a second, let me check. Till 11/7/2025. Yes, next please.
Oh, please.
May I please, Your Lordship? Madam, in the deficit postal ticket, I have already paid again on 30th, my lord. And
Mr. Debasis Patnaik for the petitioner. It is submitted that the deficit postal stamp, deficit postal stamp, requisites are all right.
already there.
The deficit postal stamp has been filed on 34/2025.
Man.
Registry shall verify and proceed in the matter for issuance of notice to the opposite party.
Man.
In terms of the earlier order dated
25/11, my lord. Interim order.
25/11/2024.
Man.
Fixing early returnable date, list after SR, list on 8/7/2025. There is an interim order.
Yes, my lord. That was on 25/11/2024.
Interim order dated 25/11/2024 shall continue till 14/7/2025.
Another I have filed for extension of interim order because the matter has been fixed to 17/5 for hearing, my lord, before the Law and Family Court.
IA is listed.
Yes, my lord, listed. Another IA I have filed.
IA number?
153/25, my lord. That may kindly be notarized.
IA 153/2025.
May kindly be notarized, my lord.
In view of the order passed today extending the interim order dated so and so, the IA stands disposed of in view of the extension of interim order dated 17/5/20 no,
Sorry, my lord.
25/11/2024 being extended till 14/7/2025.
Probably.
The IA is disposed of. Yes, next.
6.
Lord, I am appearing through VC, Lord.
Yes, please.
I am for the petitioner.
Yes.
Earlier notice was issued to the opposite party.
Yes.
In the address given in the cost of his application with, under section 9 of the Hindu Marriage Act before the Law and Family Court. When that was returned unserved, for the second time notice was issued through the court. I mean through family court, family judge Sambalpur.
Yes.
As it appears from the noting that was also again returned unserved. So I may kindly.
So have you read the noting?
Yes, sir.
Have you read the process server?
No, this is the noting of the Law and Family Judge Sambalpur.
The judge never goes to serve any notice, sir.
No, yes.
So why you are saying the judge, the process server, what he has reported?
That he has reported, he has left the place in the address. So the address which was given in the cost title of his application, he left the place.
Yes.
So I pray I may kindly be permitted to take notice on his permanent address. That is his village address.
Ramesh Chandra Sahoo appears in VC for the petitioner. Appearance likhiyo Ramesh Chandra Sahoo. I've read more. Tapar likhiye Mr. Ramesh Chandra Sahoo appears in VC for the petitioner. He draws attention to the office note put up by the registry. Office note dated 1/5/2025 put up by the registry indicating the following. SR of notice issued to OP through so and so may kindly be seen. It is submitted by the Learned Counsel that he shall take notice afresh in the permanent address of the opposite party.
Sir.
Which the petitioner presumes that is the present residential address of the opposite party.
Sir.
Because how do you know unless you discover that she is staying there?
No, sir. Yes,
but that you are not stating.
I am not sure.
That's so that's the issue. If you are not sure, you are taking notice.
Yes.
You better try to know the address. Then you take. But this process of again and again sending notice doesn't help.
Sir, kindly appreciate 4 months prior to this, he filed the application.
Sir, let us not have a drawing room discussion regarding these things.
Sir,
Let us be particular. This is a legal proceeding, sir.
Sir.
Sufficiency of notice.
No, what
You are saying, I'm unable to follow. 4 months, permanent address. I do not know whether he stays or she stays. What
sir,
is this?
The address which I have given is the address.
Sir, you don't have to tell that 5 times. If you doubt that I'm unable to follow, then you have to tell me that whether I'm following or not. I can repeat whatever you have said. It will match with the replay in the YouTube. You don't have to repeat 10 times that I have sent the notice in the address given in the plaint. I have sent a notice in the address given in the plaint. Now, for that, I have to ask you that have you gone through the report of the process server? Then you say, yes, it is that the addressee is not staying there since long.
As per the report, he left the address.
Yes, so why should you repeat those things 10 times?
Sorry, sir. So I am.
Sorry, then I will not interact. Sorry, but we must be concerned about the time spent for nothing.
Sir, permanent address by
permanent address, you are yourself not sure where she stays. This is he or she.
I'll try my luck.
He. Premananda is husband.
Yes, sir. Premananda is the husband.
Who has filed which petition? What petition? Section 9, section 10?
Yes, section 9. Husband has filed against the wife.
So you do not want to join the matrimony?
No, sir. That is the so far my instruction.
By how much time? I am giving you 1 week time. Can you obtain the address?
Sir, 1 week
distance, I can give you 14 days time. 2 weeks. Let it come on foot. No, it is submitted by the London Council for the petitioner that petitioner will try to ascertain the present address of residence of the opposite party and 6 accommodation. As prayed for list on 14/5/2025 for orders.
Sir, the 14/5 available होने can it be after vacation?
एते दिन नियंतुनी.
Sir, ମୁଁ actually प्रयागराज जाऊछु बापा बोंकर अस्थि विसर्जन
केबे प्रयागराज जिबे?
ମୁଁ ସାरे पर दिन जाऊछि 15 तारिख रे
आपण प्रयागराज रे कोन करिवे?
नहीं प्रयागराज रो गया रु पुरी देन गां को जबो सेठी टिके फॉलो ये रहिछि सो 15 रे सर मु अवेलेबल.
आपण सेना केस करले कन्वीनियंटली जिबे आपण
सर एक्चुअली
प्रयागराज has now a Delhi morning flight. You can reach and come back on the next day morning also.
नहीं सेठु सर जबो गया रु पुरी जहां हमर कस्टमर रहिछि after
you are spending too much time in traveling actually. That is the concern. आपण गया रु पुरी आज if you are traveling for 5-6 days or 1 week the 6 accommodation due to it is submitted that the Learned due to personal difficulty of the Learned Council he may be accommodated, the matter may be listed after vacation. 23/6 हबो ना फेर कोडे जिबे?
नहीं सर
ठीक है,
deeply obliged.
Yes. 23/6 for orders. आपण kindly try to ascertain something.
Section
9 petition, if you are not joining the matrimony, there is no difficulty. There is a interim order.
Yes, sir. It will kindly be extended.
Interim order, order dated?
Sir, last order, actually. Last order.
The interim order dated 13/12/2024 shall continue till date केबे देले 23/6 ଦେଇଛନ୍ତି immediate दियंतु नि 26/6 कर दियंतु 26/6 लिस्ट करंतु interim order shall continue till 4/7
oblige sir
26/6 yes
oblige sir
item 7
To Mr. Mukherjee, so I mean,
So now everything is resolved.
because somebody watching you in YouTube, this live video said that you are very annoyed. No, he's not annoyed. Who could speak to me? I mean, in that way, you can say.
The normal way or the normal tone might have sounded annoying to
No,
him,
no,
but he is
the tone is
definitely, at least
tone
we have
is
never
tone
seen
is
Mr.
tone. I mean,
Mukherjee.
voice and tone is excellent. The appearance is.
The Lordship should remove this. That is creating problem.
Yes.
That is creating the difference.
This is being worked out personally by me since last 1 week.
We find
So what is to be removed? What is to be removed and what is to be
I think
arranged?
the barrier between us has been removed now.
And even the benches in the last row and the desk also. So that I have been. I can. Yes, please. Kindly speak to the microphone.
Yes. Am I audible now?
Yes, please. Order number?
Last order, my lords, that was order number 7.
7. Yes.
The Lordship should see at para 8, which is internal page of 9.
Yes.
There your Lordships have quoted the provision of section 5 of the Admiralty Act.
Yes.
But it has not been quoted in toto, but only E instead of R. A, B, C, D, E. Whereas we were on R, so that is more of a...
No, actually I told them, but they have, but since this also they have not put any cross like leaving something you have to mark
your
it.
Lordships had specifically told that, but that is not it. So, my lord, starting from where we left off.
Yes.
Lord, before I go to the next issue regarding the amendment of the application.
Extra. Let me check. It has been assigned, so I have to check it.
It's a flag M.
Flag
M.
Just a one line, so which makes everybody happy, a short and sweet order.
No, the assignment is usually one line. When the background is described, yes.
Yes, it has been.
Yes. Yes, please.
So, your Lordships may come to the plaint, because what I have, Lord, pleaded, one is so far as the cause of action, and other is also so far as the relief I have claimed for. Because the amendment, as was pointed out, that I want to not to press for the relief number 1, which is the monetary claim. I just want to substantiate that in my pleadings, I have never mentioned that I need a monetary claim. So I'll just take your Lordships to plaint that I filed, page 11.
Internal page 11.
Internal page.
Yes. Yes. Yes.
My lords, para 15.
Yes.
The plaintiff made in personam claim against Samsung and Underwater by invoking arbitration on 20th February 2025 under the settlement agreement in accordance with the rules of the Singapore Chamber of Maritime Arbitration. The present suit is being filed for the maritime claim arising from the settlement agreement, whereas the remaining claims of the plaintiff are raised in arbitration.
Yes.
Samsung and Underwater have filed their response to the notice of arbitration denying the claims. A copy of the amended notice, so and so, my lords. It cannot be disputed that the present case is a dispute arising out of a contract for the sale of vessels, which is, Lord, R, as in section 5 of the, that is arising out of a contract where there is a contract for sale of a vessel.
Yes.
Thus, besides in personam claim against Samson and Underwater, the plaintiff has in rem claims against the 9 vessels. This
Yes.
constitutes a maritime claim under section 4, that should 4(1)(r) of the Admiralty Claims Act 2017. I think that should be 541. Okay. This is supported by the decision so and so. I'll just I'll go through those decisions later on. In the facts and circumstances spelled out herein before, it is evident that the Samson and Underwater breached the settlement agreement contained in terms of the sale of vessels between the parties by failing to execute the MOS.
Yes.
They are therefore jointly and severally liable to indemnify the plaintiff under clause 3.3 of the settlement agreement. Since Samson is the owner of the defendant vessels, in the circumstances, plaintiff is entitled to proceed in rem against the defendant vessels for their arrest under section 5(1)(a) of the Admiralty Jurisdiction 2017. At the same time, the plaintiff is also entitled to seek arrest of each of the defendant vessels under section 5(2) of the Admiralty Act 2017 in lieu of the other defendant vessel and in lieu of every other vessel against which a maritime claim arising out of settlement agreement has been made by plaintiff.
Yes.
18. The plaintiff has a claim of the indemnity amount of rupees so and so.
Yes.
Given that the indemnity amount has not been paid to the plaintiff has been constrained to file the present suit and incur cost of litigation. The plaintiff humbly submits that the cost of its litigation before the courts are to be so and so, my lord. Then your lordships may come to para 22. On the same page, my lord, that is page 13, last paragraph. May I please?
Yes, please.
While the plaintiff is filing the present suit as an action in rem against the defendant vessels for the arrest, the claims in the present suit are also subject matter of an arbitration with the plaintiff and Samson. However, the said arbitration doesn't bar the jurisdiction of Honorable Court or the present proceeding in any manner. The Honorable Court, under its Admiralty jurisdiction, can maintain an action in rem against the defendant vessels for the recovery of the maritime claim and arrest of the vessel despite arbitration against Samson. This is because in the court's Admiralty jurisdiction...
You are reading para 23?
23, my lord.
23, right.
To 23. Court's Admiralty jurisdiction, the vessel is treated as a separate juristic entity and can be sued even without suing the owners of the defendant vessels. Then 24. The arrest of a ship in Admiralty claim in rem is sequestration. Sorry, my lord. Sequestration. The term sequestration has no particular technical meaning. It simply means detention of property by a court of justice for the purpose of answering a demand which is made.
Yes.
That is exactly what the arrest of a ship is. Every maritime claimant has a right in rem which he is entitled to exercise by seeking an arrest of the ship. The only test the plaintiff must satisfy is that it has a maritime claim and establish the identity of the ship. It is not in dispute that defendant vessels are in the control of Samson. Once this is the case and the plaintiff has a claim against Samson arising from a contract for the sale of the defendant vessels, it is established that the plaintiff has an in rem claim against the defendant vessels for recovery of its maritime claim, and arrest of the defendant vessel ought to be granted. This is despite a separate and distinct ongoing arbitration against Samson. So to that extent, my lord, first I'll take lordship to one of the judgments that golden. There's a full bench judgment of the Bombay High Court. I'll just pass on the copy to your lordships.
It is JS Ocean Liner.
Yes, JS Ocean Liner versus MB Golden Progress. I'll take your lordship straight away to para 2. Or para 1 rather, my lord, that starts at page 6, internal page 6 of that judgment.
Yes, please.
The single judge of this court in his detailed order of reference had doubted the correctness of the judgment of the division.
You are reading paragraph?
Para 1, my lord.
Para 1, acha.
Internal page 6.
Yes.
The single judge of this court, because this gives the outline of the facts as well as the issue raised. The single judge of this court in his detailed order of reference has doubted the correctness of the judgment of the court in the case of Islamic Republic of Iran Shipping Lines versus MB Mehrab, so and so. So also another division bench judgment in the case of Blue Diamond Freight Private Limited versus so and so. With regard to the question of maintainability of the suit for security of the award in Admiralty jurisdiction of this court, when there is an arbitration agreement between the parties, though the arbitration proceedings have not commenced, or when the arbitration is actually commenced.
Yes.
Then, my lord, your lordship may come to the next page, para 2.
Para 2?
Yes. After hearing the counsel, so and so, the following questions arise for our consideration in reference made by the single judge. Whether an application under Section 9 of the Arbitration Conciliation Act 1996 is maintainable for the arrest of a vessel for obtaining the security of an award that may be made in the arbitration proceeding. If the answer to the aforesaid question is in the negative, whether a suit only for arresting a ship by way of obtaining the security in the pending arbitration can be maintained or proceeded with.
Yes.
3, my lord. Another facet to the aforesaid section number 2 that requires consideration is, in the Admiralty jurisdiction where there is an arbitration agreement between the parties, though arbitration proceedings have not yet commenced, or when the arbitration is actually commenced, whether the suit for security simpliciter for the award that may be made in the pending arbitration proceedings can be maintained and order of arrest made.
Kindly reread that.
Yes. In the Admiralty jurisdiction where there is an arbitration agreement between the parties, though arbitration proceedings have not yet commenced, or when the arbitration is actually commenced. So there is no question of conclusion, whether prior to the commencement or during the proceeding.
Yes.
Whether the suit for security simpliciter for the award that may be made in the pending arbitration proceedings can be maintained and order of arrest made.
Yes.
Now, my lords, I'll take your lordships to para 30, which is, my lord, internal page 14. Yes, para 30.
Yes. The peculiarity.
The peculiarity of the Admiralty action in RAME is that the coastal authorities in respect of any maritime claim can assume jurisdiction by arrest of ship, irrespective of the nationality of the ship or that of its owners, or place or business or dismissal or residence of its owners, or the place where action arose wholly or in part. In Admiralty, the vessel has a judicial personality. Admiralty law confers upon the claimant in RAME to proceed against the ship or cargo as distinguished from a right in personam to proceed against the owner. A ship may be arrested to acquire jurisdiction, to obtain security for satisfaction of the claim when decreed, or in execution of the decree. Then, my lord, that was regarding the Arbitration Act, then it has been discussed. Then I'll take your lordships to para 35, 35.
Yes.
It is not infrequent that persons who are not concerned with the arbitration may be affected by the arrest of the ship. These affected persons like charterer, cargo owners and other persons having a maritime claim are permitted to intervene in the action in rem. This is permitted by Rule so-and-so of the Bombay High Court rules. Such affected persons like charterer, cargo owners and other persons would not be entitled to have their say if the proceedings are dealt with by the High Court under Section 9 of the Act of 1996. That is the Arbitration Act.
Yes.
And Bombay being a charter high court, my lord, they have the original jurisdiction so far as Section 9 is concerned.
Yes.
In what we have discussed above, and upon taking into consideration all relevant aspects, we have no hesitation in holding that an application under Section 9 of the Arbitration Conciliation Act is not maintainable for the arrest of the vessel, and that Section 9(2)(b) securing the amount in dispute in the arbitration cannot be held to be referable rest of the ship.
Yes.
In view of the division bench judgment to that effect, the remedy of the appellant is to make an application for interim relief so and so is not correct view and is accordingly overruled.
Yes.
Then the issue number 2.
Yes.
In the, my lord, I take your lordships in the from 37, para 37.
Yes.
In the debate on this point, before we deal with the views of the counsel for the parties as well as the counsel for the interveners, we shall first refer to some of the English and Indian judgments cited before us. In MB Elizabeth, my lord also rely on that judgment. The Supreme Court observed that once a foreign ship is arrested in Indian waters by an order of the High Court, in exercise of Admiralty jurisdiction vested in it by statute or inherent in as a court of record in respect of a maritime claim against its owner, wherever the cause of action may have arisen, and whether or not the ship is subsequently released by the owner furnishing security, proceedings must continue against the owner as in any other suit. The arrest of the vessel while in Indian waters by an order of the concerned High Court attracts the jurisdiction of the competent court to proceed with the trial, as in the case in any other suit, as an action against the owner. And any decree obtained by the plaintiff is executable against any property of the owner available within jurisdiction, including the security furnished by him for release of the vessel. They are not the Rule 38, which my learned friend was saying that has been debated and it doesn't apply. I will bring that, my lord, while explaining the issue. Lord, then I'll take your lordships. I will not discuss the other judgments. Straight away to para 44.
Yes.
Dealing with the jurisdiction point, Brandon J. in Reina, thus the conclusion of the jurisdiction point which I raised in the cap bond and followed in the golden trader was from the point of view of what I believe that the law on the matter ought to be, as distinct from what I felt obliged to hold, that is, that it was an unsatisfactory conclusion. I say this for two reasons. The first reason that I think that quite apart from any international convention relating to the matter to which United Kingdom is a party, the court should have power when it grants a stay on the ground that the dispute should be decided by another tribunal of an action in rem in which security has been obtained to retain such security to satisfy any judgment or award of the other tribunal.
Yes.
When the grant of a stay is discretionary, as in domestic arbitration cases, foreign jurisdiction clauses cases and vexation cases, the court can get round the lack of such power and has in practice got round it by using alternative security method. It would, however, be more satisfactory in my view, even in those cases, to use the retention method, which is more simple and direct, which I believe commonly used in other jurisdictions. The second reason is that the Article 7 of the Brussels Arrest Convention, which is subsequently replaced by the Convention of 1999, to which the United Kingdom is a party, contemplates that a court which stays an action on the ground that the dispute should be decided by another tribunal will have power to retain any security obtained in the action for the purposes mentioned above. I drew attention to this fact, as I said earlier, in the course of my judgment in so and so. I further thought it right to point out so and so. Para 45. With regard to discretion point, on the footing that a question is an open one, it was suggested for the ship owners that a party to an arbitration agreement should be treated as having, by entering into such an agreement, abandoned the right which he would otherwise have had to security for any claim covered by the agreement. I do not accept this proposition at all. The choice of the forum for the determination of the merits of a dispute is one thing. The right to security in respect of maritime claims under Admiralty law of this country is another. Then your lordships may come to para 55. Sorry, 48. May I please, my lords? Yes, internal page 23. It starts with the Court of Appeal. Yes. But I read the quoted portion. It follows that we are with respect unable to agree with the opinion expressed by Justice Brandon that an Admiralty court has no jurisdiction to arrest or to maintain an arrest of a ship when the purpose of the plaintiff is simply to obtain security for an award in arbitration proceedings. And it also follows that in the present case, the judge aided in following that opinion and in making the declaration short by the respondents. However, the matter does not stop here. For the real point at issue between the parties in the present case, whether the club should or should not be released from its letter of undertaking. We have therefore to consider whether on the basis of that the court did have jurisdiction to arrest the ship in the present case, we should interfere with the judge's order that the club's letter of undertaking should be discharged. We are concerned in this case with the letter of undertaking given to secure the release of a ship from arrest when that arrest was obtained by a party as security for a claim which he was actively pursuing in arbitration proceeding. We have to consider the propriety of an arrest obtained in such circumstances, and we think it right to approach the question in the context of general principles governing the relationship between proceedings in arbitration and actions, in particular actions in rem in court. The mere fact that the dispute between the parties falls within the scope of an arbitration agreement entered into between them does not of itself generally preclude one of them from bringing an action. Accordingly, the mere existence of an arbitration agreement will not of itself prevent a party from issuing a writ or serving the writ, and in the case of an action in rem, procuring the arrest of the ship or otherwise proceeding with the action. But the arbitration agreement can of course consequences. For example, if an action is begun, the other party may apply for a stay of proceedings. Generally speaking, the court's power to grant a stay in such a case is discretionary, though of course in cases falling within Section 1 of Arbitration Act 75, the court is bound to grant a stay. Again, if a party actively pursues proceedings in respect of the same claim both in the court and in arbitration, his so proceeding may be regarded as vexatious and an abuse of the process of court. If so, the court may, in the exercise of inherent power, require him to elect in which forum he will pursue his claim. Next, let it be supposed that before the court has granted a stay of proceeding under arbitration acts, the plaintiff has obtained security by arrest of a ship in an action in rem. If the stay is granted in exercise of his discretionary power under Section 4 of the Arbitration Act, the court may require as a condition of granting a stay that alternate security should be made available to secure an award made in the arbitration proceedings. Here, my lord, the word used is made. Yes. In the arbitration proceedings, see the golden trader so-and-so. No such term can be imposed, but it has been held by Justice Brandon that where it is shown that the plaintiff that an arbitration of his favor is unlikely to be satisfied by the defendant, the security available in the action in rem may be ordered to stand so that if the plaintiff may have thereafter to pursue the action in rem, possibly using an unsatisfied arbitration award for the purpose of an issue of estoppel, the security will remain available in that action. Then, my lords, your lordships may come to para 60. I'm sorry, 55. that there is no clear-cut statutory provision dealing with such situation in India is not in dispute. In these circumstances, the international conventions may be of guidance. Article 7 of 1952 Arrest Convention implies that where the parties have agreed to submit the dispute to arbitration, then provided that the plaintiff brings proceedings before the arbitral tribunal within the time allowed by the court of arrest, the security will not be released but will remain in court of arrest to satisfy the award in the arbitration proceedings. Article 7 of the International Convention of Arrest of Ships 1999 provides as follows. The courts of the state in which an arrest has been effected or security provided to obtain the release of the ship shall have the jurisdiction to determine the case upon its merit, unless the parties validly agree or they have validly agreed to submit the dispute to a court of another state which accepts jurisdiction or to arbitration. Notwithstanding the provisions of para 1 of this article, the courts of the state in which an arrest has been effected or security provided to obtain the release of the ship may refuse to exercise that jurisdiction where the refusal is permitted by the law of that state and a court of another state accept jurisdiction. In a case where a court of state where an arrest has been effected or security provided to obtain the release of the ship does not have a jurisdiction to determine the case upon its merit or has refused to exercise jurisdiction in accordance with the provisions of para 2 of this article, such court may and upon request shall order a period of time within which claimant shall bring proceedings before a competent court or arbitral tribunal. If proceedings are not brought within the period of time ordered in accordance with para 3 of this article, then the ship arrested or the security provided shall upon request be ordered to be released. If proceedings are brought within the period of time ordered in accordance with para 3 of this article, or if the proceeding before a competent court or tribunal in another state are brought in the absence of such order, any final decision resulting therefrom shall be recognized and given effect with respect to the arrested ship or to the security provided in order to obtain its release on the condition that the defendant has been given reasonable notice of such proceedings and a reasonable opportunity to present the case for the defense, and such recognition is not against public policy. Nothing contained in the provisions of para 5 of this article shall restrict any further effect given to a foreign judgment or arbitral award under the law of the state where the arrest of the ship was effected or security provided to obtain its release. In different countries, different law and procedure has been provided by lawmakers. Section 11 of the Arbitration Act 1996 applicable in England provides that where the Admiralty proceedings are stayed on the ground that the dispute must be referred to the arbitration, the court may order that the property arrested be retained as security for the satisfaction of any award given in the arbitration, or order that the set of those proceedings must be conditional on the provisions of equivalent security for the satisfaction of such an award. Then, my lord, same thing where the USA and the South of law is concerned. It is thus, para 60, my lords. 60. It is thus seen that there are express statutory provisions now in place in UK, US and South Africa for retention of security. In India, there is no such express statutory provision for retention of security. The Supreme Court in the case of MS Elizabeth observed that where statutes were silent and remedy has to be sought by recourse to basic principles, it was the duty of the court to procedural rules by analogy and expediency. It was further observed that the High Courts in India are superior courts of record having original and appellate jurisdiction. They have inherent and plenary powers unless and expressly implied or impliedly barred and subject to have appellate or discretionary jurisdiction of the court. The High Courts have unlimited jurisdiction, including jurisdiction to determine their own powers. In so-and-so case, the Supreme Court said court has to approach the modern problems with some amount of flexibility, as are now being faced in the modern business trend. Flexibility is the virtue of the law courts. The pedantic approach of the law courts is no longer existing by reason of the global change of outlook in trade and commerce. In Liverpool, London, and so, in 2004-9 SCC 512, the Supreme Court observed that there were no statutory law operates in the field. Interpretative changes must be made having regard to the overchanging global scenario. If the 52 convention had been applied, though India was not signatory to it, there is no reason why 1999 arrest convention should not be applied. The counsel for the plaintiffs submitted that prior to the enactment of Section 26 of the Civil Jurisdiction and Judgments Act 1982, there was no specific legal provision in England. Well, then it has spoken about that. Then your lordships may come to para 68. That is internal page 34.
English courts.
The English courts. The English courts initially did not accept the action in rem for the sole purpose of obtaining security for arbitration proceedings. As a matter of fact, the Court of Appeal in the Vaso ruled that even though a writ in rem had been issued and the warrant for the arrest of the vessel was available, the continued arrest of the vessel would be an abuse of process to pursue both arbitration and an action in rem. However, Renake principle was called by Brandon J. that even if a suit is liable to be stayed in view of the arbitration clause between the parties, the arrested vessel or security furnished in lieu thereof was not liable to be released unconditionally. In UK, however, in the year 82, Civil Jurisdiction of the Judgments Act was enacted and Section 26 therefore substantially altered the aforementioned legal position inasmuch as it gave the court alternative security when the court proceedings were stayed because of an arbitration agreement. Thus, the statutory sanction has been given to the court in England now to retain or alter the alternative security when the court proceedings were stayed because of an arbitration agreement. Section 26 gives the court power to retain or order security for arbitration proceedings if the vessel had already been arrested or some other form of security has been put up before the court ordered a stay of proceeding. Section 45, the Act of 1996 requires the judicial authority to prefer parties to the arbitration when seized of an action in a matter respect of which the parties have made an agreement referred to in Section 44. Unless the judicial authority finds that the said agreement is null and void, inoperative, so and so. Lord, then Section 8 is dealt with, then you'll also come to para 72. We find considerable force in the argument of the counsel for the plaintiffs that it is necessary to apply Renake principle in view of the Arrest Convention 99, which is as much part of law and the statute in view of the decision of the Supreme Court in MB Elizabeth and MV C success. As a matter of fact, Mr. So-and-so also suggested, and in our view rightly, that court can straightaway apply the principle set out in Arrest Convention 99. The view of the senior counsel so-and-so also in line with the view of the counsel for the plaintiffs and so-and-so in this regard. Then your lordship may come to the next page. Para 73. The application of Article 9 of 1999 Arrest Convention in Admiralty
7, Article 7.
Article 7 of 1999 Arrest Convention in Admiralty jurisdiction in our view would be purposive and preferable. The applicability of Arrest Convention 99 in the absence of any domestic law or inconsistency with the domestic law would be more in regard to the international general principles and interaction between the arbitration agreement and in rem action. Purposive interpretation would be in consonance with the broadly accepted international procedure by which the security obtained by arrest of the ship in action in rem is retained to satisfy the judgment and award of the arbitral tribunal. Such constructions shall neither be in conflict with Section 45 of the Act of 1996, nor the judgment of Supreme Court in so-and-so cases. In the cases of P. Anand Gajpati Raju and Hindustan Petroleum Corporation. The subject matter did not relate to an action in RAIM, nor the Supreme Court was concerned with the question of method as provided in 1999 Arrest Convention. Then your lordship may come to para 77. We are of the view, it starts. We are of the view, absent explicit legislation providing that action in RAIM may be used to obtain and retain security, even though the merits of the dispute are to be determined in the arbitration proceedings, and subject matter of the dispute falls within Admiralty jurisdiction, some procedure which is not prohibited and that is also not inconsistent with the law be devised which helps in advancing the cause of justice in accord with Article 7 of Arrest Convention 99. We shall accordingly articulate our conclusions thus. An application under Section 9 of the Arbitration Conciliation Act 1996 is not maintainable for the arrest of the vessel for obtaining security of an award that may be made in arbitration proceedings. The view to the contrary in imbue so-and-so to that extent is overruled. An action in RAIM in Admiralty jurisdiction for recovery of the claim and arrest of the vessels where the parties have agreed to submit the dispute to arbitration can be maintained. And in such case, if by way of an interim measure the vessel is arrested and the security provided to obtain release of the vessel, matter shall proceed in accord with Article 7 of International Convention of Ships, 1999. If the proceedings are brought within the time so ordered by the court before arbitral tribunal, any final decision resulting therefrom shall be recognized and given effect with respect to the arrested ship or to the security provided in order to obtain its release, provided that the defendant has been given reasonable notice of such proceedings so and so. With regard to clauses 2 and 3, it is however clarified that the retention of security shall remain a matter of discretion and it shall be for the court to pass appropriate order in that regard after taking into consideration all relevant circumstances. Then, my lord, this was before the 2017 Act came. Then, my lord, later on, again the Bombay High Court in 2018, relying on this principle and the new law, lots of it is 2018 SCC Online 2730. Yes, it's a single bench judgment which has been confirmed by the division bench later on. The same within the same parties. I'll take a lot. Para 2. Plaintiff had obtained an ex parte order of arrest on 1st June 2018 from the vacation judge. Defendant is an offshore supply vessel platform vessel flying the flag of Liberia and presently at Mumbai within the territorial waters of India and within the Admiralty jurisdiction of this court. According to the plaintiff, the defendant vessel is owned by MEDS and MEDS has denied this fact. According to MEDS, they are only the bareboat charterers of the vessel and the owner is someone else, which is Shorefish Shipco Limited. Plaintiff has filed this Admiralty suit inter alia for recovery of amount of so-and-so, which includes charter in the sum of rupees so-and-so and claim for capital value of the vessel in the sum of so-and-so together with further interest and cost. It is plaintiff's case that the plaintiff had entered into a bareboat charter party dated 13th May 2015 with the owners of the defendant vessel and the owners of the defendant vessel committed a breach thereof. According to the plaintiff, my lord, para 4, the next page. According to the plaintiff, plaintiff is the owner of the motor vessel CM Merlin. By the said bareboat charter party, plaintiff gave on bareboat charter the same to maids for a firm period of 5 years with a purchase obligation at the end of the 5 years or a purchase at the end of first, second, third, fourth year from the date of delivery. Then, my lord, your lordships may come to para 5 because thereafter the actual all the aspects and the notices have been issued or they discussed. According to the plaintiff, sometime in November 2017, plaintiff learned that maids had purchased defendant vessel Altus Uber. Plaintiff relied upon a Sea-Web report dated May 2018, which confirms that maids was the owner charter of Altus Uber. Therefore, plaintiff filed this Admiralty suit in this court for the same identical claim that it has made in the arbitration proceedings in London. Plaintiff obtained the order of arrest as mentioned above. According to plaintiff, notwithstanding the pendency of the arbitration proceeding and award that may be passed in London, plaintiff is entitled to file the present suit seeking arrest of defendant vessel as security for plaintiff's claim in the suit.
Mr. Nanda, may I just interrupt
Yes,
you
sure.
with these are the arguments and merits regarding amendment or the suit?
Amendment. Well,
Regarding the amendment you are saying.
There are two issues. One, as they said, if my valuation goes or if my prayer in the amendment is allowed, then it changes the nature and character of the suit. And also, conversely, whatever they have filed, that Order 7, Rule 11 will automatically go. Then the amendment to the order, which I have said that, like pending this acceptance of the my application for amendment, I should not be insisted upon me to pay the court fee. That also goes, because this will become the crux of the issue. If my suit, irrespective of the amendment, if the amendment is allowed, is also maintainable and it doesn't change the nature of or character of the suit, and I delete that prayer regarding the claim, so whether I can maintain the suit or not, number one. Number two, the other issues will follow.
Regarding maintainability of or a future suit, you can say that's another issue. But regarding seeking amendment,
yes,
part of the claim, as you have placed that para 16 and all those paragraphs in your plaint where it is quantified. So changing that and as a result.
No, there I have said, my lord, that it is to indemnify or to create a security. Only in the prayer where I have made the prayer in the first prayer. If you're
my understanding is your contention is that suit is maintainable. The answer would be yes. I think they will not disagree that suit is maintainable. But here, regarding the amendment to be allowed. So I mean that's the question has to be answered.
Then, my lord, I'll take your lordship on the two judgments, one the Cuddalore versus Cuddalore, and there is one more that life insurance.
You just carry on. You carry on in your own way.
No, my lord, I'll not definitely try to waste the
because what I have followed from their submission that they are not arguing regarding maintainability of the suit.
No, they're talking about rejection
now
of the suit.
Suppose you see the provision also is very clear that for a claim it can be a subsequent.
So they are praying for rejection of the suit on the basis of the non-payment of court fee. So
yes,
now, if the valuation of the court fee changes by virtue of the amendment,
and that would change if it is amended.
If it is amended,
or the amendment is allowed.
If the amendment is allowed, whether the entire suit fails,
I think they have not gone to that extent in challenging whether post amendment.
No, they have.
Suppose post amendment on merits, because it is yet to come.
No, what they have said, if I go by what Mr. Mukherjee argued that day, that since I did not comply with the order by 16th of April, my suit becomes non-existent. So there is no question of amendment of it.
No, in fact, that order 611 or 711 was filed earlier.
Yes.
So they have an answer to your prayer for amendment. I mean, they seeking a relief of the pleadings the suit doesn't survive. in view of so and so orders and rules, order of the CPC. But answer could be different. Yes, answer is different to the regarding allow of prayer of amendment. The answer would be different. That their answer is that it changes the nature and character of the.
No, but it doesn't change the
But
nature.
but I think
this
both the
It
things
may-
are not answered by the plaintiff together. It is to be answered separately. In the sense,
Yes,
suppose
but my simple submission to that is the nature and character of the suit is not changing. The claim, because my pleadings say that I require this to indemnify and as a security. Maybe my prayer is not rightly worded or whatever it is, but the court has put the court fees on it, has been assessed. And as they say also, and as if we go through the order sheet also, we have, as it appears, accepted the valuation of the court fee. But whether, now the question is, if this amendment is allowed, whether that will remain or not. Because if it doesn't remain, does it actually change the nature and character of this?
that means you mean that will remain or not? You mean to say
If my amendment is rejected, let's say, my lord, my application for order 617 is rejected, then the original plaint stays as it is, then I am bound to pay the court fee. Because that has been the order. I cannot escape that order. Whether it will be after that automatic.
but here the sequence is a little bit different. You take a order from the court stating that this is the suit valuation. Court fee, maybe Court Fee Act, we have to look at the what is the stages. But it is understood that even if at the initial stage, it can be extended. So it has been extended. Then that order has not been complied with.
No, my lord. The order of extension and the arrest order are on the same date.
Correct.
I have taken arrest order prior to the
absolutely
prayer for extension. It is on the same date, the same order as the sequence as your lordships saw that, because in this case IA number 7, then IA number 6 on 19/3. So it's not that I have taken an ex parte order and even before paying any court fee. I had paid court fee, but not adequate court fee.
No, that cannot be attributed to the court. The fact remains that court's order, because the fact remains that you.
I'm saying it is on the same day.
No, attributed to the court's order in the sense. The fact remains that you can and you have sought for extension of time to pay the court fee. That has been granted. Unless that is granted, the court could not have proceeded with the matter.
With the arrest.
Because that deficit court fee would at the threshold would have barred the court in entering into any other further orders.
Exactly.
Perhaps that is the way you can look at it. Yes, court has granted that. I mean, there you are right that both the orders are together, but yes.
Yeah, maybe what went through the mind of the court or what was the impression at that point of time, that might have weighed in with the court's views. So I'll just take, before I come back to this, I'll just take a look to the two judgments.
No, you can finish this. You can finish this.
If your lordship should come to para 6, that is internal page 3.
Yes, please.
It is in this background that Maid's applicant has taken out the present notice of motion for vacating the order of arrest. According to applicant, the plaintiff, having already commenced arbitration in London, cannot file the suit for the same relief. If plaintiff wanted any security, it has to take steps under the English Arbitration Act, so and so. The C-Web report, which notes Maids are the owners, is incorrect. Even though plaintiff has sought for a decree, in effect, reading the plaint as a whole or on a holistic reading of the plaint, it is evident that the main intention for filing the present suit is only to obtain security pending arbitration and nothing else. Averments or decree are only cosmetic with no intention of pursuing the same, because the plaintiff, having elected to go for arbitration and proceeded with the arbitration by filing statement of claim, this suit cannot go in for trial. Once security is furnished, that will be the end of the suit, and therefore effectively the suit is filed only for security until the enforcement or execution of the arbitral award. Such a suit is not maintainable in view of the judgment of the apex court in so and so. Yes, even after the new Admiralty Act, the Act does not provide for security in foreign arbitrations, which provision was there under Article 7 of the International Convention of Arrest of Ships 1999, and the Admiralty Act has excluded that provision. Similar to Article 7, the suit for security pending arbitration is not maintainable. It is the plaintiff's case that the arbitration is an action in personam against meds, and the present suit is an action in rem against the defendant vessels, and both are maintainable. The full bench of the court in that golden progress, which I read out, my lord, just before this,
Yes.
has noted
Yes, Ocean
that,
Liner.
yes, has noted that absent explicit legislation providing that action in rem may be used to obtain and retain security, even though the merits of the dispute are to be determined in the arbitration proceedings, and the subject matter of the dispute falls within the Admiralty jurisdiction, some procedure which is not prohibited and that is also not inconsistent with the law be devised, which helps in advancing the cause of justice in accordance with Article 7 of Arrest Convention 99. Then the Arbitration Act, that is not relevant. Then D, just because an action in rem cannot be maintainable for arrest of a ship under Section 9 of the Arbitration Act as held by full bench of this court in golden progress, it does not mean that the plaintiff will be rendered remediless, mainly because an action in rem in the facts and circumstances of the case, independent of the arbitration, was maintainable, and just because there was an arbitration clause and the plaintiff commenced arbitration in London, does not mean the plaintiff should be put to disadvantage. And Article 7 of Arrest Convention provided for a situation where arbitration proceedings have been commenced and an action in rem was maintainable for security pending arbitration. The Admiralty Act does not bar the provisions of 1919 Arrest Convention as held by the apex court in so-and-so cases and golden progress. If the law is silent, there is no express prohibition and the provisions are not inconsistent with the law.
Yes, please. Yes.
I'm sorry. A procedure can be devised which helps in advancing the cause of justice and MVC success. So-and-so the apex court has held that 1999 Arrest Convention can be applied as a provision of law in India. Then your lordships may come to it. The lordships may straight away come to internal page 22.
You are referring to the plaint or the
no, my lord, the judgment.
The judgment.
Yeah.
Paragraph?
Paragraph 52.
52.
We may
Yes.
start with.
Yes.
From the judgment of mariner, so-and-so the following position emerges. The jurisdiction to do justice is a part of the jurisdiction which a court of record has.
Yes.
52. That is internal page 22. Where the statute is silent and judicial intervention is required, courts strive to redress grievances according to what is perceived to be principles of justice, equity, and good conscience. Prima facie, no matter is deemed to be beyond the jurisdiction of the superior court unless it is expressly shown to be. The Admiralty jurisdiction of the court is invoked in action in rem when the court arrests the vessel for securing a maritime claim. It is only when the owner of the vessel puts in an appearance and gives security that the action becomes an action in personam. The clause for arbitration is not between the plaintiff and the vessel, but between the plaintiff and the owner of the vessel. This clause for arbitration will be given effect to after the court exercises its jurisdiction to arrest a ship. It is from that stage that the provisions pertaining to arbitration have to be considered. The power of the court to do justice is inherent to it at all times as long as the court is seized of the matter. This power to do justice between the parties is not taken away by the provisions of the Arbitration Conciliation Act 1996. The power of granting interim relief till the parties are directed to proceed in arbitration continues with the court. The same observation apply with equal force when it comes to the provisions of Admiralty Act 2017. And there is no express provision in the Act, nor by implication can it be understood that the powers which are inherent to the court to do justice to the parties are taken away. It is thus clear from the above judgment of M.B. Smart, M.B. Mariner, and M.B. Elizabeth that an action in rem gets converted into an action in personam only after the owner of the liable in personam enters appearance and submits to the jurisdiction and furnishes security. It is only after that this happens that the arbitration provisions are required to be considered and given effect to. As held in MV so-and-so, in personam proceedings are no bar to an action in rem. Consequently, applying the principles set out in the aforesaid three judgments and the judgment of MB Elizabeth to the facts of the present case, it is clear that it was open to the plaintiff to commence in personam proceedings by way of arbitration in respect of its claim, and also to commence an action in rem for arrest of a defendant vessel. It is only after the owner or the party liable in personam enters appearance and submits to jurisdiction and furnishes security that the action would continue as an action in personam, and it is at that stage this Honorable Court would supply the procedure devised by the full bench in golden progress to retain security for the benefit of the arbitration commenced by the plaintiff. Golden progress is only devising the procedure based upon legal principles as set out by various judgments and referred to above, including M.B. Elizabeth, to ensure that the cause of justice is served. And based upon principles of justice, equity, and good conscience, which are a hallmark of the administration of justice. Jurisdiction to arrest a vessel to secure a maritime claim is also an equitable jurisdiction to do justice to a claimant and ensure that he is able to realize the fruits of a judgment, decree, or award that he may eventually obtain, whether by way of arbitration or in court proceedings. The overriding principle there is that the High Court, being a court of equity, it is equitable principles that must guide the court in a matter of interlocutory orders. The procedure devised by the full bench is consistent with these principles and can be adopted in the facts and circumstances of the present case to secure the maritime claim of the plaintiff by the action in rem and arrest of the defendant vessel. A right in rem is a valuable right that a party has for the purpose of obtaining security in respect of a maritime claim. To debar a party from approaching the court on the ground that the party has agreed to arbitration would amount to depriving a party of his vested right to file an action in rem under the Admiralty Act 2017. This right cannot be taken away unless there is a statutory bar or an express provision denying such a right to a claimant. There is no such bar or prohibition under existing law. Neither is there any bar to the exercise of this right under or in court. On the contrary, considering the distinction in rem and in personam proceedings, it is manifestly clear that a right in rem is available to a claimant notwithstanding the commencement of in personam proceedings in respect of the same claim and cause of action. This is because right in rem in Admiralty jurisdiction is essentially available to secure a maritime claim by arrest of a ship.
Yes.
It is only after the owner of the ship enters appearance and submits to jurisdiction and provides security.
Your argument is during penetration proceeding at Singapore, this action in rem is possible to initiate.
So, since I have raised that claim before the Singapore arbitration or also in the Gujarat suit, I did not pursue, or it is not, if I don't pursue that claim also, the suit's nature and character won't change. Because the suit's character might have changed had I taken it as for an execution of the award post-award, if I would have sought, which is not permitted. So for a security, as my pleadings say, when I'm seeking a security against a future award or a future order of a court, where the same claim arising out of the same agreement between the same parties is pending, can it be said that if I don't pursue this relief, the nature and character of the suit changes? And my answer is no. Because no.
The schedule of amendment you have filed.
Yes.
So that is in Word file or it is, what is the procedure? It is PDF. Because while answering your argument, as it will be now, this has to be answered by Mr. Mukherjee, of course. So the court may have to reproduce that. So it will be better if you give that in Word file. It's not difficult.
We can give it, my lord,
to the court
masters. Take it out in a
yes.
Word file. So I'll, my lord, come back to those two judgments on.
So for this much as far as this CM offshore, para 58.
Para 58.
Yes.
Oh, my lord. And that has been also repeated again in para 61 and the other. But this is the principle, my lords.
Yes.
Then, my lord, the conclusion, if your lordships would see, that is at para 66, 67.
Yes.
Para 66 at page 28. My purpose of placing this judgment, my lord, is to show that as required under Order 6, Rule 17, they won't lose any right to defense by amending this prayer. And so far as the court fee is concerned, that I have a right. That also I'll, my lord, give the judgments also. How it is to be affected, and if at all, if there is a pending suit, there is another suit, then how it will affect that also. That also, my lord, the judgment is. The lordships may come to para 66.
Yes, sir. The above reasoning equally applies.
The above reasoning equally applies when considering in rem arrest for the purpose of obtaining security in a case where arbitration proceedings had already been commenced, applying the procedure devised in Golden Progress. It matters not whether arbitration has been invoked or is yet to be invoked. Any other interpretation would not only defeat the interest of justice, but would be contrary to the avowed objectives of courts and parliament to promote alternative dispute resolution by way of arbitration or mediation. If a party agrees to arbitration, it cannot be that he is to be deprived of his right in rem to obtain security in respect of his maritime claim. Just as a party who agrees to arbitration with the seat of arbitration outside India after the 2015 amendment can apply for interim measures to a court in India under Section 9 of the Arbitration Act 1996, irrespective of the fact that arbitration may have already been invoked before any such application is made, so also a party should not be deprived of his right in rem to invoke Admiralty jurisdiction and obtain arrest of a ship to secure his maritime claim, even if arbitration may have been already been invoked. As noticed earlier, also after 2015 amendment under Section 9 read with Section 2 of the Arbitration 96, a party can approach this court for securing the amount in dispute in the arbitration, even in the arbitration. Just because the party cannot maintain an admiralty action in rem under Section 9, can such a party be deprived of a chance to secure its claim in arbitration? In Golden Progress, the full bench has in para 78, as I read out before your lordships, held that the court has to devise a procedure to permit a party who has agreed to submit disputes to arbitration, and as noted earlier, there is no explicit legislation barring such security. Plaintiff had given their vessel so and so, my lord, then 69. As per section 5.2 read with section 5.1b of the Admiralty Act 2017, plaintiff is entitled to arrest a vessel which is either owned by or on demise charter to Meds when the arrest is effected. So that is yes, though the issue, my lord, if I say, was under Order 7 Rule 11D, not C per se, but the issues remains almost like the same.
Yes, Kadalur versus Kemplast.
Yes, ma'am. My lord, we take your lordships. Issues for determination, my lord, page 17.
Paragraph?
Internal page 17.
17.
Yes. That is regarding order to rule. Your lordship's got.
Yes, yes.
Having heard the learned counsel appearing for the party and having gone through the materials on record, the only question that falls for a consideration is as follows. Whether in the facts and circumstances of the present case, the principles enumerated under Order 2 Rule 2 CPC would bar institution of a second suit and warrant rejection of the plaint filed by the respondent number 1 herein OS number so and so. Then the analysis, my lord, the Order 2 Rule 2 has been placed. Then, my lord, at para 38. Order to Rule 2.1 requires, your lordship's got.
Yes, please.
Every suit to include the whole of the claim which the plaintiff is entitled in respect of a particular cause of action. However, the plaintiff has option. Excuse me, Lord, sorry, just for a second.
Yes, to relinquish, yes.
Yes. Has an option to relinquish any part of his claim for the purpose of bringing the suit within the jurisdiction of any court. Order to Rule 2 contemplates a situation where a plaintiff omits to sue or intentionally relinquishes any portion of the claim which he is entitled to make. If the plaintiff so acts, then he shall not afterwards sue for the part or portion of the claim that has been omitted or relinquished. It must be noted that Order to Rule 2.2 does not contemplate the omission or relinquishment of any portion of the plaintiff's claim, which leave the court so as to entitle him to come back later to seek what has been omitted or relinquished.
Yes.
Such leave of the court is contemplated by Order 2 Rule 2.3 in situations where a plaintiff being entitled to more than one relief on a particular cause of action omits to sue for all such reliefs. In such a situation, the plaintiff is precluded from bringing a subsequent suit to claim the reliefs earlier omitted, except in a situation where the leave of the court has been obtained. It is therefore clear from a conjoint reading of the provisions of Order 2 Rule 2 and 3 CPC that the aforesaid two sub-rules of Order 2 Rule 2 contemplates two different situations, namely where a plaintiff omits or relinquishes a part of the claim which he is entitled to make, and secondly, where the plaintiff omits or relinquishes one out of the several reliefs that he could have claimed in the suit. It is only the latter situation where the plaintiff can file subsequent suit seeking the relief omitted in the earlier suit, provided at the time of omission of the claim of the particular suit relief, he had obtained the leave of the court in the first suit. Then, my lords, so that is why, my lord, we have stated that we are changing the relief.
This Order to Rule 2, it's more kind of a factual aspect. I'm asking you for your clarification, or rather my clarification, that Order to Rule 2 comes to, if you read Order to Rule 2, just kindly refer to that CPC.
May I please?
Yes, please. Suit to
include the whole claim.
Yes.
Every suit shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action. But a plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of any court.
Yes, please then
relinquishment of part of claim.
Yes.
Plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished.
Yes.
Omission to sue for one of several reliefs. A person entitled to more than one relief in respect of the same cause of action may sue for all or any of such reliefs, but if he omits, except with the leave of the court to sue for all such reliefs, he shall not afterwards sue for any relief so omitted. For the purposes of this rule, an obligation and a collateral security for its performance and successive claims arising under the same obligation shall be deemed respectively to constitute one cause of action. So, my lord, before going to the judgment back, my lord,
just kindly look at the illustration.
Yes.
A lets house at B to B
at a yearly rent of 1200. The rent for the whole of the year 1905-19 is due and unpaid. A sues B in 1908 only for the rent due for 1906. A shall not afterwards sue B for the rent due for 1905 or 1907.
Does this Order 2 Rule 2 has a bearing on this particular your
relinquishment part? While since your lordship stated on the last occasion when the matter was being heard that if I relinquish this part.
No, I didn't say that, because you relied on that
Umrao
judgment. Umrao Devi
was only for the reason that I can. It is not that what I will, but I can part with not making or relying upon or, my lord, pressing for a relief. Because here there is a difference between claim and the relief. What I am leaving out is the relief of payment from this court, because that is already in arbitration, already before the Gujarat court. So in the subsequent suit, I don't want the same relief from the court.
I mean, the arrested vessel, the long and short of the, the entire, the facts could be, the arrested vessel is not to be valued.
Yes, it can be.
It has to be valued. So there is a change in the valuation.
No.
Change in the valuation because of the change in the claim.
No, my lord. The valuation remains the same what I had valued earlier. This, your lordships are stating about the suit if it is to be executed.
No,
and
the
if
court fee. Court fees act.
Yes.
If you look at court fees act. What do you call?
7(3), your lordship.
Sorry?
7 Roman 3.
Rule section 7 Roman 3.
Roman 3.
For other movable property having a market value.
Yes.
Then in 4, my lords. For a declaratory decree and consequential relief.
That is not the case here.
Because my amendment is that I need a declaratory relief and I need injunctive relief.
I'm holding for the other movable property having a market value in suits
Yes.
for movable property. Other than money where the subject matter has a market value according to such value at the date of presenting the plaint. Mr. Nanda, you are referring to 4.
4. My lord, that 2. First is for a declaratory
So
decree and
Orissa
a
amendment, there is a amendment to 4. Clause B omitted by Orissa Act of
Clause B. Among C and D. Because if my amendment is allowed, it will come under C and D.
7C and D.
7C and D. 7 Lord IV, then C and D. That is for declaratory decree and consequential relief and for an injunction.
You are having this book because it is so interspaced by case laws that you can't correlate the section where it starts and where it ends. So if you can no, I have that.
Okay.
Court fees act seat kadunanti central act re. Eଠି ଅଛି। Yes, you carry on. Or after recess.
Subject.
Yes,
No,
yes.
then I require a lot for 20 minutes. This was, I have a prefix matter in court number 3 at 2 p.m. It won't take more than 15-20 minutes. So we can restart
Yes,
at 2:30.
you can inform Mr. Mukherjee the time you can start.
2:30. 2:30 you'll also, because that won't take more than 20 minutes. my lord.
I'll continue the further matters.
Yes. at
Passed over hela author call karibe.
2:30 we can resume.
Yes. Call karantu. Court fees act एंटी नहीं आसन पता चैम्बर भी थाई करे
आइटम ए
मेंशन है चीज़ नहीं सीरियली जान item 8 yes sir this is for sufficiency of notice or otherwise so why you want pass over your name sir can you look at the cause list कौन पे लिस्ट है ये देखंतु please look at for why it has been listed Ashok Kumar Patra you have power here Mr. A.K. Patra for the petitioner if a matter is listed for sufficiency of notice after notice matters you have to understand what has happened so by passing over what would happen the pending case is pending at the matter that is pending upon ki jan you have power here AK Patra achhanti apana Mr. A.K. Patra for the petitioner 6 adjournment. The registry shall obtain updated postal tracking report regarding service of notice to opposite parties 2 to 5. When do you want, sir? Apna kebe chahunchandi?
after vacation.
After vacation. Diyantu date. As spread for list on 36 20 25. Yes.
Item 9.
तब out add कर दियो तो registry shall also verify if any learned counsel has entered appearance for any of the opposite parties. For the opposite party, any of the opposite party into bracket IS कर देले हो. Plural. Yes, item 9.
9 may I please your lordship. Noting is that neither
Mr. G. Sahoo.
My lord.
For the petitioner. Opposite party blank.
It is not back from opposite party number 1 and 4, my lord, yet. Noting is there. In pursuance to order dated 17/3/2025, I filed
the learned counsel for the petitioner refers to the office note put up by the registry that the neither AD nor service return has reached the registry to confirm service of notice. The registry shall verify the shall obtain up to date postal tracking report and also shall verify if learned counsel has appeared for any of the opposite parties. केबे चाहछन मिस्टर साहब?
After vacation.
आफ्टर वेकेशन डेट कर दियो 2/7 लिस्ट ऑन 2/7 2025.
Interim order to continue.
Interim order dated
17/3, my lord.
17/3/2025 shall continue till the next date of hearing. आरोटार भी जो इंटरिम ऑर्डर थियो कर देबे. तो कॉल मेंशन कले नहीं, still you do it. Yes.
Item 10. Item 10, Mr. Pati was there, other side appearing.
After that, Mr. Parthasarathi Naik has appeared.
Now Mr. Pati is.
Manoj Pati is appearing.
Manoj Pati. ते पढ़े कल इटा बेस समय चलियो बोले पढ़े काम.
अच्छा.
Passover. After recess.
The after recess the shoot will continue. But anyway, ଆପଣ ଯଦି କହିବେ ନା you wanted did he inform you any date?
It is an admitted case. ମାନେ ସେ ରହି ଗଲେ dispose of ଯଦି ହେଇଯିବ ଯଦି ସେଟା ନ ପରିବ ତାହେଲେ next week.
Mr. Pati was there.
Pati was
Mr. Agasti Kanun go for the petitioner. Mr. M.K. Pati for the opposite party CGC से ना senior panel counsel. M.K. Pati कौन अच्छा? Senior panel counsel. On consent गोटे date कर दियो तो?
Next week
कर दियो गोटे date छुट्टी पूर्व कर. से next week कोचंती.
No.
On consent list on 9/5/2025. Yes, next.
Item 11.
Yes, Mr. Bishwan.
But 11, there is two matter.
This is after notice hearing matter.
After notice.
So that we cannot initiate now. So the leftover matters after this admiralty suit will be taken up on Monday. Will be added to the Monday's list. Let us see how this hearing of the admiralty proceeds.
Can it go after vacation?
If you agree for a date, you can suggest. Mr. Niranjan Bishwal for the petitioner. You are appearing, sir, for?
I'm from opposite parties, Life Insurance Corporation. That's it.
ଆପଣଙ୍କ ନାଁଟା?
AK Mahanti, Ashok Mahanti.
ତ୍ରିଲୋଚନ ପାଣିଗ୍ରାହୀ ଗୌତମ ମିଶ୍ର ଏମାନଙ୍କର କଣ ଏଟା? ସେମାନେ they are also appearing?
No.
Mr. Ashok Kumar Mahanti, OP number 1 and 2. 1 and 2. Substituted opposite parties combined. Mr. Panigrahi is appearing. He usually appears in VC from Puri. Anyone there? क्या अच्छी Puri रे?
The last occasion also they are not appeared.
It is submitted by the learned counsel, Mr. Mahanti, that he has instructions to appear on behalf of the opposite parties 1 and 2. Name of the learned counsel appearing earlier for the opposite parties 1 and 2 shall be deleted from the cause list as well as the case brief from the next listing. On consent list on date करो तो after vacation go. 3/7.
May I please your lordship? I am to BC lordship. Item 11. Sorry,
Yes.
lordship. Some net problem. I could not join lordship. In this case, I am from the petitioner. In case of WPC 11950/2016, lordship. Here the petitioner.
So since you were not present, and this is after notice matter, it is not likely to reach. So the learned counsel are suggesting after vacation.
Okay.
ଆପଣଙ୍କ ନାଁଟା କଣ?
Yes, Mr.
S. Mishra.
Aye.
On behalf of Mr. T. Panigrahi for the. You are appearing in the first matter as opposite party? For the opposite
party 3.
3.
Opposite party 3. First matter in second matter.
Small a, small e. Likhi. Small a, small e. 3A, 2, small e. Miss S. Mishra. First matter. ହେଲା କଣ ଆପଣ ଅର୍ଡର କୋଟା ଲେଖିଥିଲେ? ନାଇଁ ତାପରେ ସରିଲା କୋଉଠି? ସରିଲା କୋଉଠି? So order complete ହେଇଯାଇଛି. Second matter ଲେଖନ୍ତୁ appearance. Miss S. Mishra on behalf of T. Panigrahi for the petitioner. Mr. Ashok Kumar Mohanty for OP1 and 2. Mr. Biswal, you are appearing for?
3.
Mandakini Misra.
My lord.
Mr. Niranjan Biswal for OP3. On consent list on 2/7. Sorry, 3/7. 3/7
My lord, 3/7 is the Saturday. Let's put out 2/7. So the Friday, so that it will.
No, 3/7 was Thursday. It actually July city asini. July city lagaye. Se samna re rakhiya padibo. Apon jodi actually I understand the difficulty. That apanakara reopening pare jota apanakara third week hobo.
My lord. My lord.
उन्नीस 26 होची जून मासरे जुलाई मासरे
Thursday.
Yes. Rest of the matters after recess, any mentions?
My lord, next item 12. I am from the opposite party. Petitioner.
No, any matter not taken up or not reached, no adverse order, it will be added to the list on Monday.
Okay.
So no difficulty.
My lord, in item any 12, I am for the on behalf of Mr. Mahathi, my lord.
Yes.
Let it come 2 weeks after. He is otherwise engaged out of
sorry, I forgot your name.
No. On behalf of the Mahathi, item 12.
Apan nata kon?
PC Das, myself PC Das.
PC Das. Mr. PC Das on behalf of Bhagavan Mohanty for the petition. Mr. Niranjan Biswal for the opposite party. Kete number? 2. Say 2 weeks mane after vacation. Mr. You agree for a date, Mr. After vacation. But a date kar diyo. 3/7. On consent list on adjournment is sought for on behalf of the learned counsel for the petitioner on ground of personal difficulty. On consent list on 3/7/2025.
Item 10.
Yes, Mr. Ratha.
After lunch,
because it becomes difficult to take up a particular matter since this will continue.
Then in that event is item number 15.
15.
Matter on 7th, my lord. This can be kept on 7th.
Yes.
My lord, I am there for the opposite parties. There are 4 matters. In
Central Bank of India.
Again?
Central Bank of India, you are appearing.
Ditara move.
Mr. J.K. Ratha, 15 lekhantu. Mr. Ratha, senior counsel, instructed by Mr. D.N. Ratha for the petitioner.
2 p.m.
Mr. S.K. Misra for the opposite party. On consent list on 7/5/2025. 7.
7/5.
Lordship. Yes, sorry. वो पार्टी रो सेटा भाव चापणो जोड़ा कहया करता. Yes. Next.
Item.
Batch case रे सबुडा ऑर्डर करते हैं.
Item 10 my
on consent list on एते appearance लिखि देबे. Yes, Mr. Das. Yes, Mr. Mohanty.
Item 10 रे मु थिली.
आपण लेखा है चीज आपण कोली कहले आपण अछती खाली तो ओनली डाउट वाज आपण सीनियर काउंसिल पैनल काउंसिल ना सीजीसी
नहीं सीनियर पैनल
लेखा है ता भी ठीक लेखा है
चलो ठीक लेखा है.
In item 24, my lord.
Yes, 24.
24. My name is not reflected in the cause list, my lord. Prakash, correct the Rakesh Kumar Rautera, Prakash. P is omitted, my lord.
P लिखा हो ठीक है जी P लिखा है along with Mr. Niranjan Biswal.
Yes, my lord.
So TRP CRL सेटा कोन आपनकर अदर साइड अछंती
transfer right.
ताल सेटा reach जदी reach न कला don't worry, it will be listed. It is not going, any matter is no matter is going out of list.
चारिटा केस जाजपुर अछि गोटे केस से ट्रांसफर करिया चंदन
Let us see. अरे सी तो नाहांती आपण एबे कहले केमती हो. Let him come. So even if you are not there, no adverse order is to be passed.
No.
Because the fixing of the hearing of the suit, so it will continue around 2:30. It will start. So maybe you will not be getting time also. So rest of the matters after recess. Thank you.
I may be part.
Yes, please.
My lord, item 22.
Kindly speak to the microphone. Item 24 you are saying.
I'm 22.
22.
Aye.
Yes, 22.
I have informed Mr. Mishra to remain present in VC. And I.
So Mahanti was there also. Yes, Mr. Mishra.
Vacation, my lord.
When do you want?
After vacation, my lord.
7.
7.
7, 8.
Or a fair
7.
Sir.
7, 8.
अच्छा 8-7 all matters.
Both matters.
That matters only.
22 लिखूं तो Mr. Somnath Mishra for the petitioner, Mr. ND Tripathi for the opposite party on consent list on 8-7-20-25. Which item ଅଛି sub item?
My lord, item number 21. I am in VC, my lord. KC Kanon go.
Yes, Mr.
Item 21.
21.
I have informed Mr. Vikram Senapati. If my lord will be pleased to accommodate me for today, so at least I will be highly obliged. All 5 hour matters.
Yes, Senapati was meeting. So have you agreed for a date?
That is the post.
I have informed you.
Item number 19.
No, item 21.
19 is also connected.
No,
Item 21 having 5, I say, 5 sub-items.
Will fix it today.
Yeah, no, actually, I'm taking up this 21 is mentioned.
That,
Just kindly speak to the microphone, sir.
Well,
I'm unable to hear you. Sorry.
Item 21.
Kindly speak to the microphone.
That is regarding the post-retirement spouse.
Acha.
Last week it was there.
Huh.
Tata Power.
No, basically.
Section 57 is very clear. That
So,
is after amendment,
since that suit is being heard, so and it has been again the hearing has been adjourned only for passed over.
Let it be taken last matter. It will take only 5 minutes.
So it can be next week. It will be there in the list.
Monday, Miller.
Yes. Usually the leftover matters it will be attached to Monday list, but I am not very sure how many urgent matters are there for Monday. So it may at best spill over to Tuesday. But
my problem, Miller, is 79.
Yes. You told that.
Can it be taken Monday first matter, Miller? Other side also they have filed.
No, it will not be the first matter. It will be in the list. It may be the second matter or the first matter. I cannot say because it will be added to the list.
I will mention.
Only I request that the registry that they maintain the position.
I will mention on Monday. Let it come on Monday, Miller.
Or it is taken up leftover on Tuesday. So it is accommodated.
My problem is I will not be.
So you need not worry. Don't worry. It is added to the Monday's list and it will be taken up.
No, I will not be available.
On Monday.
I wanted Monday.
So Tuesday kar diyo. Tuesday is 6th. 6th you will be available.
Okay.
May I repeat my submission, my lord?
I may be pardoned.
Item 21 I have submitted.
Sorry.
I am 21. I have submitted, my lord. Can I be please accommodated for today only? I am.
So it will be added to Monday's list, or you want?
My lord, yes, my lord, Monday.
It will be added.
My lord, item 21. I have informed the other side.
Yes.
Obliged, my lord.
Item
21 order होनी, आपण simply add कर दियंतु हैला. Yes, Mrs. Mahanti.
Tuesday, my lord.
Yes, 20 Tuesday कहउछंती.
6th.
6th. Unless any specific adjournment is required, the matter will be listed. No difficult. Yes. Adjournment call कर देवा ठीक अछि. आपण call करंतु ताले.
Item 13.
Mr. Bono Bihari Ray for the petitioner. Mr. S.K. Sahoo on behalf of P.K. Mahanti Senior Counsel for the opposite party. On consent list on 24/6/2025.
Item 16.
अपन जोटा 13 लिख लेंगे 13 anyone appearing for the who is appearing for the state. The matter is assigned to Mr. Prabhu Prasanna Behera, additional standing counsel for OP1. Mauthor Dakuchi, appearance. Mr. P.K. Mahanti, instructed by S.K. Sahoo, OP2 and 3. Senior counsel, OP2 and 3. Again. एक हेले एसी 2-3 हेले पूरी म्युनिसिपालिटी हैला नेक्स्ट कॉल करंतु
16.
Mr. Sisir Kumar Purohit for the petitioner, Mr. A.K. Nath for the opposite party. Learned counsel for the opposite party seeks accommodation. The learned counsel for the petitioner opposes the prayer for adjournment as prayed for list on 24/6/2025.
17.
Mr. Ambarish Misra, A. Misra on behalf of H.S. Misra for the petitioner. 17, anyone present? For the Union of India? Opposite party blank? Adjournment is sought for on behalf of the learned counsel for the petitioner due to personal difficulty. As prayed for list on 3/7/2025.
18.
Mr. S.K. Sahu on behalf of P.K. Mahanti for the petitioner. Mr. K. Ponda, CGC, for the opposite party. On consent list on 2/7/2025. Yes.
19.
Mr. C. Ananda Rao for the petitioner, opposite party blank. Learned counsel for the petitioner seeks accommodation list on 6/5/2025. नहीं सेटा चेंज करंतु सी आनंद राव सीनियर काउंसिल इंस्ट्रक्टेड बाय एसके बेहरा तापर लिखिए आज फॉर लिस्ट ऑन 6/5/25 अब इसे लिखो यस
Item 20.
मिसेस अर्चना महांती फॉर द पिटिशनर फॉर स्टेट item 20 who is the counsel? Mr. Rajdeep Pradhan, additional standing counsel for OP1. Actually, Sanjeev Swai, standing counsel for the. Just a second. Rajdeep Pradhan for opposite parties 1 to 4. 1 TO to 4. Mr. Sanjeev Swai, standing counsel for OP5. On consent list on 6/5/25.
Item 22.
21. Miss Korchundi, she mentioned kale. Mr. Kanungo, your matter, when do you want? You are muted. Kindly unmute, Mr. Kanungo.
My lord.
केबे कहउचंती फेर म्यूटेड हे गले अगेन यू आर म्यूटेड सर
सर म्यूट कटि मु तो म्यूट करतो अनम्यूट कली
अच्छा देयर इज सम इश्यूज टेक्निकल केबे चाहउचंती
13th or 14th my lord
you have taken consent of Mr. Senapati
yes I have informed him my lord
no will it come on next week or 14th what do you
14th will be easy one better
Mr. Bikram Senapati for the petitioner, Mr. K.C. Kanungo for the opposite party. Counsel for the opposite party seeks accommodation on consent list on 14/5/2025. All the matters,
my lord. Similar matter.
Charita. Yes, next please.
23.
अरे 22 again छाड़ले कौन डका है ठीक है सेटा कहिबे ना मिस्टर सरोज कुमार पाड़ी 22 डेट टा 8/7 Mr. Somnath Mishra for the petitioner, Mr. N.D. Tripathi. N.D. Tripathi for the opposite party. 8/7 लिखिले 23 लिखंतु सरोज कुमार पाड़ी एसके पाड़ी for the petitioner, Mr. BPB Bahali for the opposite party. The learned counsel for the parties seek adjournment on consent list on 1/7/25. Second matter same. SK Padi for the petitioner, Mr. BPB Bahali for the opposite party. Yes, call करो जल्दी करो। नहीं 24 रे गोटे अच्छी मेंशन है। और मार्क करना है तो 24 लिखो।
Item 24.
Mr. Petitioner blank chat दियंतु। Opposite party Mr. Prakash Kumar Raut. ହେଲା। On mention, it is stated by the learned counsel, Mr. Raut, that his name has been wrongly typed in the cause list. Registry shall indicate the name correctly. That is Prakash Kumar Raut. Single quote. Hala? In the cause list as well as the case brief. केबे को देबे 24 टा केबे नेक्स्ट कहि ना कोन दियन जल्दी बिफोर वेरिफिकेशन कर 13/5 लिस्ट ऑन 13/5 यस नेक्स्ट
30.
Mr. 30 Mr. R.C. Swai for the petitioner, Mr. S. Das for the opposite party. Learned counsel for the party seek accommodation. Parties seek accommodation on consent list on 2/7/2025.
Item 38.
Mr. 38, who is the state counsel? Mr. Sudhir Chandra, Mr. M.K. Ponda. M.K. Ponda for the appellant. 38. M.K. Ponda for the appellant. Mr. Rajdeep Pradhan, additional standing counsel for the respondent. Learned counsel for the appellant seeks accommodation as prayed for list on 30/6/2025. Mr. Raut, you are suggesting a date for listing the matter.
Item 37 my lord.
जोटा मेंशन कले आपनकर प्रकाशटा राकस हे जाईची
पर केरी
सेटा केबे को चाहुचंती आपण
आज सजियो
नहीं आज रीच करिवनी
ने किछि
so the court master has given a date of 13th or you want any other earlier date कल कहंतु जल्दी कहंतु
next week
मतलब 24 is adjourned to
24 as your name sir आपण को नाटा
अक्षय जन एके जन
अच्छा 24 रे लिखंतु petitioner AK जेना हां A.K. जेना Mr. Prakash Kumar Raut for the opposite party देखो 8 कर दियंतु हां 8 13 अच्छा ठीक है 13 अछि से 13 देइछन
sir item number 37 my lord. My lord item 37
जोतरी जे परे आसी कहबे अपीयरेंस में ता नोट करी दे देबे हला
item 37 my lord.
Mr. Senapati, your matter Mr. कानून को मेंशन सो केबे को डेट देइछंदी हां because he mentioned today not likely to reach
देखि 14/5
so 14/5 But he could not say the date because whether he has talked to you. So that is how I said ki 14/5.
Item 7.
My lord, item 37, my lord. I beg pardon to mention item 30.
Beg your pardon, my lords. Item 26, my lords.
26.
My lords.
No, you want adjournment or listing?
I am for the opposite party, my lords.
No, you want listing or adjournment?
My lords, listing I want.
Listing all other matters which have not been specifically mentioned by any of the learned counsel. It remains in the list. No difficulty.
My lords.
No difficulty. It will be coming on Monday or Tuesday. I mean, as the list permits.
My lords.
Since because of this hearing of the Admiralty suit, so that is some there is some difficulty in to wait for the matters to reach.
My lords, I'm grateful.
I may pardon my item number 14.
14. You want specific date or
No, after vacation.
who is for the other side?
I'm the opposite party.
Petitioner Gandhi.
Now, because
In absence of the petitioner, it's after notice matter for admission.
no, he has already filed a petition for early hearing. He fixed a date for that.
So more so, you want any day next week will be convenient? Monday most likely it will come.
No, maybe on Wednesday.
Wednesday ଚାହୁଁଛନ୍ତି ଠିକ ଅଛି 14ଟାକୁ simply କରିଦିଅନ୍ତୁ Wednesday ମାନେ 7 ତାରିଖ 7 ତାରିଖ କରିଦିଅନ୍ତୁ.
My lord, item 27.
27, what do you want? You want adjournment?
It may come next week, my lord. We both are present.
All matters are, sir, they are in the list. It will be listed on Monday or Tuesday. No difficulty. But beyond 7, it is difficult to reach all the matters. So that is how whoever is mentioning the matters are adjourned. If you do not want adjournment, please don't mention. It is in the list. Sorry?
Item number 30, my
130.
Okay.
Yes, what do you want, sir?
Adjournment.
କେବେକୁ ଚାହୁଁଛନ୍ତି?
ଧନ୍ୟବାଦ. After vacation.
नहीं, ଆପଣ ରମେଶ ଚନ୍ଦ୍ର ସ୍ୱାଇଁ ଆପଣଙ୍କ ନାଁ କଣ?
On behalf of Biraja Prasanna Das.
It has been mentioned. ଆପଣ S Das.
My name is Gyanendra Mahanti.
नहीं, S Das mentioned in the morning. It has been already adjourned to 2nd of July. Already adjourned. Mr. Swai mentioned that Mr. Das was there. So it has been adjourned. Yes, call କରନ୍ତୁ.
Item 7.
But I was on that order to rule 2.
Yes.
The judgment, my lord, another that just passing on.
That Kadalur power gen.
No, Kadalur is that paragraph 38 only, which I read out before.
Kadalur para 38 only.
38.
Yes, yes.
Lord, this is LIC versus Sanjeev Builders.
So why you are not printing both sides? Because it becomes so bulky. At least the volume immediately reduces to.
My copy is that, but when we give for photocopy, they make it single side.
No, it is better to make it single. I mean both sides.
Because for them, it doesn't become like.
It becomes voluminous.
That's it, separate judgment. 2022-16 SCC, page 1. That's LIC versus Sanjeev Builders. The lawsuits may straight away come to.
Yes.
There are 45. Where the Lord, that is internal page 24 of the judgment.
Yes.
The same order to rule 2 has been quoted along with the illustration also. Which will also see on the next page.
You're referring to para 45.
45. But Lord,
Yes.
that's where it has been quoted.
Yes.
So 46, I'll just take your lordship. The expression omits to sue. Lord, it starts with lordship.
Yes.
And intentionally relinquish any portion of his claim. Gives an indication as to the intention of the legislature in framing the said rule. The term sue can mean both filing of the suit and prosecuting the suit to its culmination, depending on the context of the provision. In the present case, the legislature thought it fit to debar a plaintiff from suing afterwards for any relief which he/she has omitted without leave of the court or from suing in respect of any portion of his claim which he intentionally relinquishes. Order 2, Rule 2(1) provides that every suit shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action.
Yes.
The provision of Order 2, Rule 2 CPC has been then para 47. Well discussed by the Privy Council in so-and-so case held as under. The principles laid down in the cases thus far discussed may be thus summarized.
Yes, please. Sorry. Please carry on.
Fine. And para 47, my lord, the court.
Yes.
Correct test in cases falling under Order 2, Rule 2 is whether the claim in the new suit is in fact founded on a cause of action distinct from that which was the foundation of the former suit. The cause of action means every fact which will necessary for the plaintiff to prove if traversed in order to support his right to judgment. If the evidence to support the two claims is different, then the causes of action are also different. The causes of action in two suits may be considered to be the same if in substance they are identical. The cause of action has no relation whatsoever to the defense that may be set up by the defendant, nor does it depend on the character of the relief prayed for by the plaintiff. It refers to the media upon which the plaintiff asked the court to arrive at a conclusion in his favor. The observation was made by so-and-so, then your lordships may come to para 51. Then the other cases have been discussed. In the light of the principles discussed and the law laid down by the Constitution bench, as also the other decision discussed above, we are of the view that if the two suits and the relief claim therein are based on the same cause of action, then the subsequent become barred under Order 2, Rule 2 CPC.
Yes.
However, we do not find any merit in the contention.
No, Mr. Nanda, in fact, again, I'll reiterate. You need not labor on this point actually. I think that Umrao Devi, that's a High Court decision. Well, there was a Andhra Pradesh Suit Valuation Act. That's one way of, that's one aspect of it. But I think the case doesn't turn on this particular aspect.
No, man.
Suppose in the sense, suppose you seek the leave Order 2, Rule 2, something like it says that without leave of the court, then the answer and the context should be different. That is what I was telling you.
No, for the amendment, that principle is laid down also in this case. That's why I laid out certain paragraphs.
So, but whether you can, alter the prayer or you can say relinquish a portion. What could be the parameters within Order 2, Rule 2?
Yes,
they may have a case, but I think we are not reached
that stage.
So that is how I simply said that their answer could be different or would be different. Yes.
So the lordships may straight away come to para 71 and 71.2 onwards.
Yes. Final conclusions.
Yes. 71.2. All amendments are to be allowed which are necessary for determining the real question in controversy, provided it does not cause injustice or prejudice to the other side. This is mandatory, as is apparent from the use of the word shall in the latter part of Order 6, Rule 17.
Yes.
Prayer for amendment is to be allowed if the amendment is required for effective and proper adjudication of the controversy between the parties.
Yes.
To avoid multiplicity of proceedings, provided the amendment does not result in injustice to the other side.
Yes.
By the amendment, the parties seeking amendment do not seek to withdraw any clear admission made by the party which confers a right on the other side.
Yes.
And the amendment does not raise a time-barred claim resulting in divesting of the other side of a valuable accrued right.
Yes.
Prayer for amendment is generally required to be allowed unless by the amendment a time-barred claim is sought to be introduced, in which case the fact that the claim would be time-barred becomes a relevant factor for consideration.
Yes.
the amendment changes the nature of the suit.
Yes.
The prayer for amendment is nullified.
Yes.
Or by the amendment, the other side loses a valid defense.
Yes.
So now, my lord, analyzing these issues, my lord,
since you are reading all the points, you can continue, complete it. 71.5.
All right. In dealing with the prayer for amendment of pleadings, the court should avoid a hyper-technical approach and is ordinarily required to be liberal, especially where the opposite party can be compensated by costs. Where the amendment would enable the court to pinpointedly consider the dispute and would aid in rendering more satisfactory decision, the prayer for amendment should be allowed. Where the amendment merely sought to introduce an additional or a new approach without introducing a time-barred cause of action, the amendment is liable to be allowed even after expiry of limitation. Amendment may be justifiably allowed where it is intended to rectify the absence of material particulars in the plaint. Delay in applying for amendment alone is not a ground to disallow the prayer. Where the aspect of delay is arguable, the prayer for amendment would be allowed and the issue of limitation framed separately for decision. Where the amendment changes the nature of the suit or the cause of action so as to set up an entirely new case, foreign to the case set up in the plaint, the amendment must be disallowed. Where, however, the amendment sought is only with respect to the relief in the plaint and is predicated on facts which are already pleaded in the plaint, ordinarily the amendment is required to be allowed. Where the amendment is sought before the commencement of trial, the court is required to be liberal in its approach. The court is required to bear in mind the fact that the opposite party would have a chance to meet the case set up in amendment. As such, where the amendment does not result in irreparable prejudice to the opposite party or divest the opposite party of an advantage which it had secured as a of an admission by the party seeking amendment, the amendment is required to be allowed. Equally, where the amendment is necessary for the court to effectively adjudicate the main issue in controversy between the parties, the amendment should be allowed. In the overall view of the matter, we are so and so, my lords. Now, coming back, my lord, to the findings or the conclusions at 71.3.2.
Yes.
That is to avoid multiplicity of proceedings. Provided the amendment does not result in injustice to the other side. Now the question is, injustice comes when there is a legal right for something. Now, so far as my plaint is concerned, as I pointed out, I have not read out the plaint contents. It is only for security and indemnity. Now, they have not acquired a legal right to object to my deletion of that or the amendment application. Because the claim or the monetary claim which I was seeking here is also there faced with the same claim before the arbitration also. It is not that, let us say, my lord, on res judicata my suit is dismissed. Because it is the same claim before two forums. Can they escape their liability vis-a-vis the first suit? The answer is no. Can they escape the liability vis-a-vis the arbitration proceedings, as I read out in the earlier judgments? The answer is no. And the speciality of this act, my lord, the Admiralty Act and the peculiarity of it, it's a right in my favor to pursue simultaneous proceedings before different courts because of the special issue regarding the jurisdiction of that court, because of the subject matter being within the territorial jurisdiction of that. Normally in suits, what happens, my lord? It is a single cause of action or multiple cause of action, but within a particular court jurisdiction. Or there would be a separate suit where there would be a separate cause of action. Here, for the same cause of action, arising out of the same agreement, settlement agreement, arising out of the same claim in relation to the subject matter of a single document or instrument, I can pursue multiple remedies. That is the difference been brought in because of the Admiralty Suit Act. And that is why that I read out, because the arbitration proceeding pending will not take away my right. And so far as the claim is concerned, if they say that claim creates a right, it's not a legal right for them. It may be vis-a-vis, but not for the defendant to say, I have acquired a legal right so that the amendment will become or will cause injustice to me if it is allowed. Then the second is, by the amendment, the parties seeking amendment do not seek to withdraw any clear admission made by the party which confers a right on the other side. There is no question of admission here. It's purely in the plaint. Plaint is not sought to be changed, neither the cause of action is sought to be changed. It is merely the reliefs that I have claimed for that I seek the change of it. So absolutely no right has been created in their favor as on date even to object to my amendment application. Then the amendment, Lord, I'm sorry.
Yes, please.
A lot of you are taking notes on it.
Yes.
The amendment does not raise a time bomb resulting in divesting the other side of a valuable accrued right, which doesn't arise at all here. Because there is no question of time barred claim, neither there is a pleading to that effect, nor defense or anything.
Yes.
Because it is not. Then, my lord, 71.4. A prayer for amendment is generally, because the first one said why it should not be. The second one said why it should be. 71.3 was why it should not be. So if these if these reasons are pointed out, then it should not be allowed. Now why it should be allowed. 71.4.1. By the amendment, a time barred claim is sought to be introduced, in which case
actually it is
I'm sorry.
it is unless. So 71.
I didn't read that line, a prayer.
Yes.
A prayer for amendment is generally required to be allowed unless by the amendment a time barred claim is sought to be introduced, in which case the fact that the claim would be time barred becomes a relevant factor for consideration. Then second, the amendment changes the nature of the suit. Now here is the question, my lord, which is primary issue before your lordships, as was pointed out by them on the last occasion also, that it changes the nature and character of the suit. My respectable submission is, keeping in view the plaint and the pleadings, my sole prayer would have been for injunctive and declaratory relief. And that is there, present. I am not introducing a new prayer into it. On the contrary, I am taking out a prayer which, if at all, causes any injustice, brings any fetters of law will be against me. Because rather they will be in a position, if at all, to raise that issue, that whether we read it as relinquishment, deletion, XYZ, anything. By the amendment, if I am giving up something, how are they affected? What right of theirs is adversely affected? Even if for the matter of res judicata also, that will become, for them also it will always remain. And if they want to plead that, okay, you have given up there, how can you bring it up in any other proceeding? That is available to them. But how can they stop me from amending my application to that extent? Then it will be a different cause of action for them. So my amendment application has to be read in consonance with the plaint that I have filed, the original plaint. And in the context of the amendment I am seeking, and the pleadings I have made in the amendment application which I want to bring in. It cannot be that if it reduces the court fees, that cannot be a ground. Because for pecuniary jurisdiction, that is the purpose for which I read out the earlier judgment of the Hyderabad High Court. That to bring within the jurisdiction of a particular court, a party can always reduce the valuation of the suit. Like in a declaratory suit, parties can go to the lowest forum, can go to the highest forum also. Because a declaratory relief is, when they seek a declaratory or injunctive relief, the valuation is purely the choice of the plaintiff. So higher the amount, he will pay the amount or the court fee on that. So the fetters or the restriction on me from seeking the amendment and at the initial stage, they have not even filed the WS, forget about the trial of it. So at that stage, what right they have acquired or what legal right rather would say they have acquired to say that it should not be allowed. Because if it is allowed, then these are the consequences. So what right? Yes, they have said that it will reduce, now the valuation will change, the nature and character will change. Merely saying is not what it is. Because it has to be read because the amendment is sought by me of my plaint, my cause of action, my right which I want to establish before a court of law.
So your submission is that though it reduces the court fee payable, but nature and character remains intact.
Remains the same.
There has been no change.
Absolutely no change. And even if otherwise also, the claim which was there, on the said claim in the other suit before the Gujarat High Court, I have already paid the court fee. So they can always, the difficulty is that is there, this court fee will not be for that purpose. It has to be separated, it has to be bifurcated. Because the valuation of that suit would be this and this.
No, the difficulty is that perhaps it is also suggested that this requires an amendment for these reasons. It's 2017, yes. But the statutory mandate is that yes, it's a claim. You can choose your places of proceeding. You have chosen Gujarat and Odisha, and both places you have to pay the court fee.
Yes.
I mean, if suppose there is a legal provision or a provision in the Valuation Act or the Payment of Court Fees Act, whatever, that once a suit is filed, it is a judgment. It's a suit in rem, so only one court fees has to be paid. But that is not the prescription of the law.
No.
The prescription is if you have chosen a place of
different places, you have to pay differently.
Pay differently.
No, I'm just saying that on that valuation, on the total entirety of the claim, because my claim arises out of a single instrument, claim remains one. One is before the Gujarat High Court is also the same, before the arbitrator also the same. So if I decide to forego the same relief from this court, one is a claim, one is a relief. So if I forego the same relief I seek from this court, what right is created or like what right of the defendants is violated by that if I do it? Because if I have to see, because the fetters which have been set in the judgment as well as in the act, it is that my amendment should not take away any of their rights which might have accrued to them. Now, matter of court fee is not a right so far as the defendant is concerned. The first thing. Second, so far as the court fee, if my amendment is allowed, I have a right to have an amendment which I chose. That yes, I need to amend it. They cannot raise an objection because their right to defend the suit is not taken away by virtue of that amendment. And the reliefs that I have sought in the plaint remains the same except for the monetary valuation of the relief I have claimed. and the arrest of the vessel or otherwise are the reliefs which are sought and which are not changed. Those are the substantive reliefs. And as per my plaint, I have clearly stated that it is for the purpose of security and indemnification. I have not said that it is to execute or to satisfy an existing award or an existing decree. No, neither that is the requirement of law in advance.
Enforcement of contract?
Enforcement of contract is specific performance that I have not sought here. That's an arbitration. So what I want to change in my prayer is to confine into injunctive and declaratory relief. That is why I said Section 7 of the Court Fee Act. That is why at that point of time, if your lordships would, again, I'm sorry, my lord, taking back your lordships to Section 7 IV.
Yes, in suits.
In suits. And in that, C and D, for declaratory decree and consequential relief, to obtain a declaratory order where consequential relief is paid, then D, for an injunction, to obtain an injunction. So,
yes,
according to the amount at which the relief sought is valued in the plaint or memorandum of appeal, in all such suits, the plaintiff shall state the amount at which he values the relief sought.
Yes.
So now if my amendment is to be allowed, if it is rejected, that's a different issue because that the original order will again prevail. If it is allowed, the court fee has to be revalued. Then what I have paid, if it is not sufficient, I will make good the rest of it. If it is sufficient, even in cases, there are cases where refund can also be sought. So the entire question hinges on the issue whether this amendment is to be allowed or not. And the law that is, which has been, as I read out, I'll just give one more judgment where again the same issue has been raised regarding Order 6, Rule 17. If a right has already been created in favor of a party,
yes,
that is sought to be taken away by way of an amendment. Because that is the, my lord, sum and substance of the judgment and the principles I read out. Then only it should be rejected. Otherwise, it has to be liberally construed and it shall be allowed. That is the wording I'll, my lord, read out Order 6, Rule 7. So in normal course, when an amendment is sought by the plaintiff, it should be allowed by the court, subject to examining whether prior to seeking such amendment, a legal right or a right under law which will get defeated if amendment is allowed, or a time barred claim or those things, my lord, which is technical in nature. Otherwise, the rest all have to be allowed. Now, for a moment, my lord, your lordships, I will take your lordships to Order 6, Rule 70.
Yes. Departure.
Amendment of the pleading. The court may at any stage.
You are referring to Order 6?
Order 6, Rule 17.
17. Okay.
Amendment of pleading.
I was referring to Order 6, Rule 7. Yes, amendment of pleadings.
Amendment of pleadings.
7 and 17 are related.
Yes. To some extent, but there's a.
Yes, so only by way of amendment you can bring. So that is 17.
The court may at any stage of the proceedings allow either party to alter or amend his pleadings in such manner and on such terms as may be just, which is regarding the cost factor and all that, if the amendment is allowed. And all such amendments shall be made as may be necessary for the purpose of determining the real controversy between the parties, provided that no application for amendment shall be allowed after the trial commenced, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. So the only factor is once the trial is commenced.
Yes.
So the statute is not even that elaborate like the judgment.
Yes.
Which has elaborated this provision in those judgments which I showed you lots of, and the other judgment I'll show. That everything should be allowed.
Yes.
At any stage but before the trial. Which may be necessary for the purpose of determining the real questions in controversy between the parties. My lord, here what is the controversy in this present? It is not the claim, because the claim is to be decided by the arbitrator. Admittedly. There is an arbitration proceeding. There is an arbitration clause. And as per Admiralty Act and as per my pleadings, what is in substance to be decided by this Honorable Court is my right to get that security or indemnification.
Yes.
Because there cannot be simultaneous proceedings for the same claim. And in the arbitration, as I read out in the first term, my lords, under Section 9, I don't have a right under Section 9 to get the ship arrested. So what I am left with. So that is why the Admiralty law is different from Arbitration Act and the other laws. The reason being, irrespective of the fact that the controversy or the claims between the parties may be decided in a third forum, for the purpose of securing the claim before that forum, I can approach one or more high courts wherever the properties are situated. Now, my lord, taking for a moment, I will just get back for a moment to that Admiralty Act. Why the monetary relief is not so important under the Act. If your lordship may come to Section 4 also. Your lordship's call.
Yes, please.
4.1. The High Court may exercise jurisdiction to hear and determine any question on a maritime claim against any vessel arising out of any dispute regarding the possession or ownership of a vessel or the ownership of any share therein. Now, regarding a vessel ownership. So, ownership is not a monetary claim. It's a declaratory claim. Pure, simple declaratory relief which can be raised, which can be admitted and adjudicated as an admiralty. Just one example, my lord. The other there are other things, but I just wanted to point out before Lordships that it doesn't make it as a precondition when I file an Admiralty suit that there has to be a monetary claim attached with that reliefs to make it maintainable. I can maintain it without any monetary. And what I am seeking as an amendment is not to make the monetary or not to press upon the monetary. I am only on the issue of security and indemnification. So my amendment does not come under any of the category under Order 6 Rule 17 as pointed out by the Honorable Apex Court, which should deny me the amendment. It is not a question of allowing, because allowing is the norm. It should be allowed. So the courts have said only in these issues you may deny. So the presumption of law or the requirement or the purpose of law is that every amendment which is filed by a party, because he is the person who raises the claim or who claims any right, so he becomes the master of the suit. Thank you. So I should, because that word I was missing a lot. He being a civil giant, of course, it's a day in, day out proposition for him. So to that extent, it is my right to seek the amendment. And the court has to examine. And unless the court sees that these are the issues which will or which are taking away the rights or the legal rights which has already accrued, on the respondent, then otherwise the law, which is the normal law or the purpose of the law is, it should be allowed. And before the stage of trial.
Yes.
It's only that after the trial starts, then the proviso to Order 6 Rule 17 comes. So prior to that, because if the trial has not started, they have every right to object, every right to seek for any relief, interim or otherwise, or rejection, anything. But till such time, unless it is for the court to allow the amendment, not for the opposite party to see, unless they come up with a case where there is a legal right which is accrued in their favor. In their objection, as that day pointed out by my learned friend Mr. Mukherjee, they only said malafide. I'll come to that. Malafide, misrepresentation, then it will change the nature and character. And what in effect I want, because I want to reduce the court fee.
Yes.
So now the question of
So, sum and substance is that that para 71 in LIC, the exceptions carved out by the Supreme Court or pointed by in the interpretative process, you do not come within those exceptions.
Within those exceptions.
Yes.
And also the same has been again reiterated in very recently in 2024.
No, let us not multiply these.
No.
If you have anything more in that list of 71.123,
almost the same.
So then
It's almost the same.
because it is
Maybe
quite elaborate.
There, but it doesn't take away the context in which it has been.
Because I think it's quite elaborate.
Quite elaborate.
In fact, the arguments of the senior Mr. Mukherjee is in fact is also covered in those that unless.
Yes.
Because he says this is what it is. So that is how it is not to be allowed.
Yes.
Yes. So any other, other interpretative expansion of these points, then you can supplement. Otherwise, not necessary.
Because no, the second issue, or I can say in few words, so far as the malified is concerned, that's a matter of trial. Amendment, allowing the amendment or not allowing the amendment, that cannot be a reason.
No, you look at 71.4.3.
Yes, that malified is where malified has to be proved if they have in their objection application.
Your answer is that it has to be proved in the way of in the form of a trial.
As an issue. Because that cannot be a ground for rejecting it. It will become an issue in the trial that whether this, whatever I have brought in by way of amendment, with a nullified intention. And misrepresentation has no place in that. So in sum and substance, my lords, I would say that unless those criteria are met, where the unless has been given and those things. And the first thing your lordships have
Just a moment, just a moment.
I'm sorry. So, Lord, while coming to the issue regarding the, Lord, what the court has to examine is to see if I'm coming or my seeking the amendment application is coming within those parameters where it says why it should be denied. It is not why it should be allowed. Second issue is whether by virtue of my seeking the amendment, any legal right that has already accrued in favor of the defendants, if it is taken away. Third issue is whether court fee or non-payment of court fee. If my amendment is allowed, that's a separate issue. Whether non-payment of court fee at the first instance can be a ground, because that is where they put the malified, because they say that they have undertaken, then they have mentioned at different paragraphs and all that misrepresentation and malified. Whether that can be a reason for not allowing the amendment. Because that is not, as I read out within that para 71, those reasons are nowhere present. And the quantum of court fee, as your lordships know, it's a matter between the state and the plaintiff. That doesn't create a right in favor of the defendant. The defendant's claim will, or the defendant's plea can come only after the consideration.
Discussion in Umrao Devi, LIC, or that this is Kadalur.
Yes.
CM, actually, the discussions is not regarding the regarding the impact on the defendant itself.
Yes,
the discussion is also between the state and the.
No, apart from that, it is only the plaintiff's case. It doesn't say what defense
Your
they have
contention is
taken.
beyond plaintiff's case, nothing to be looked into.
Unless otherwise it has created a right, pre-existing right. Before I file the plaint or the way the plaint is filed, that itself filing of the plaint, whatever may be the reasons to be read out from that plaint, if it has already created a right in favor of the defendant,
yes,
that after their appearance, had it been prior to their appearance, let us. There are two instances it can be. One is prior to the appearance of the defendant. One can be post appearance. Now, prior to the defendant's appearance. like the Act or the court said that it is a time barred claim, which for the court to examine. Court could not have allowed that. But if it has allowed, it has created or done injustice to a legal right which has already accrued in their favor, because the plain reading of my claim. So post the defendant appearing, also if there has been any legal right pre-existing on the face of the plaint itself, unless that is created, till the trial begins, I have every right to amend, and court has to allow it unless those conditions are fulfilled.
Yes.
So to that limited extent, my lord, I leave on this only regarding the amendment, because that has to be taken up as your lordship stated. So to that, if your lordship want, may I reply on the other issues? I can, the other IAs.
No, other IA because
that will be
because
depending upon
other
this.
IA, you can give your response to this rejection of plaint. That is IA number.
I think 8.
Mr. Mahanti?
11.
8.
8.
Or
11. 8 is vacation. 11 is order 7 rule 11.
Order 7 rule 11 is 8.
Order 7 rule 11 is 11. IA number 11.
Okay. Yes.
So, my lord, if I read there,
but anyway, perhaps since
upon this.
Yeah, exactly, because I mean, maybe as a strategy, or you have not asked for an extension of further time.
No, in my prayer in 15.
Further time for payment of the deficit court fee, as you had undertaken in the earlier 6 or 7, IA 6 or 7. So that you have not filed because you are seeking amendment. Suppose the amendment is allowed, then
I don't need that period.
Don't need that. But their prayer also, yes, Mr. Mukherjee, you respond to this of Mr. Nanda's prayer for amendment.
They have not applied on not argued on the modification application, nor on my application for order 7 rule.
Correct. In fact, I was telling
let him complete. I will give a rejoinder in one go.
Acha.
Let him complete.
Then, my lord, I suppose that.
Yes.
If
you have your time. You have your time.
My lord, because your lordship, like yesterday, said that we'll be on the amendment only.
No, so, the reason being regarding the assignment, I was not sure. Both of you were not sure also regarding the assignment, but now the assignment makes it clear that I have to take it. I have to take up everything. So maybe in a way, suppose but yes, if I answer the amendment in the negative, then I may not have to go to the others. But since they have already filed it earlier, that way you can have your submissions. Because
to be very honest, my lord, I have not paid.
No, absolutely. You take your.
Extremely sorry, my lord.
No, not at all. Because even I was not aware till yesterday evening that they are listing it. There was some delay in giving this pen drive. Then around 7:30 or 8, he says that because of the ADMLS, so it has been again redone. So because I don't know, you might have moved the registry for listing, or they might have moved. So that is how they have listed. So,
otherwise, also, my lord, off the record, I can say that I will not. Because I am not that hard pressed as my friend is. So
Admiralty has the advantage of having only one bench.
Yes.
So in the morning when I mentioned that, I said that is it a new matter, you list it. So that's the standing instruction to the.
So that is why also we both have agreed that yes, your lordships can also note our contentions.
So you agree for when it can be listed?
Tomorrow, subject to your lordship.
Tomorrow there is a DB. That specially assigned matters.
In rejoinder, I'll not take more than 15-20 minutes. So
since he has somewhat elaborated his arguments on these points, this you can say also responded to your contention regarding whether the amendment should be allowed or not.
Yes.
So that it comes. Yes.
I am a big stakeholder in this case, Lord.
Yes.
I have filed an intervention. I'll just take your lordship's 10 minutes after he says in reply.
Yes.
I'm a big stakeholder.
Yes. That day they were not there. You were there. You said that you come into picture if the amendment is allowed.
Yes. But I'll tell your lordships, amendment is allowed. Otherwise, I come into the picture, merits also. But
Merits
I just
also.
take your lordships 10 minutes
yes.
after Mr. Mukherjee says, I'll just take 10 minutes of the lordships.
So I will record your submissions. Today's submissions. So,
only I pray, Lord, if it can be on Tuesday, because Monday.
Tuesday. Yes.
Tuesday, subject to my seniors, both the seniors there.
ଦେଖନ୍ତୁ cost title same ରହିବ ADMLS ରେ ଯାହା ଅଛି appearance same ରହିଲା so
Tuesday
is okay. Of the earlier order dated
only
sorry
is your lordship, if your lordship is keeping it to Tuesday, if they my only request is let them conclude on that date so that I can also give my
No, I will.
Because I am
that I may not.
I am suffering I am at the receiving end.
I understand.
Because this was the primary, so that's why it took so much of time. Otherwise, my lord, within 1 hour, I'll finish the other replies.
No, since the upcoming vacation is there, you have to accommodate the other matters also.
I fully understand.
Yes.
I fully
That's
understand
the other part of it.
That's why.
But no more hearing in other. Yesterday, I could complete one hearing in one appeal, but maybe other.
Sometimes, my lord, also we feel guilty on this side that.
On Tuesday, let it retain its position and your lordship subject to.
Item 7. Item 7. You can take your seat. I'll just record his submissions.
Yes.
Your lordship's permission, can we file short or synopsis kind of a thing on this?
Since I am concurrently writing the order sheet, so if you miss anything, you can structure your submissions on base of that synopsis. No problem.
Yes.
But I don't want to expand the pleadings. Yes.
Maybe a couple of pages or
yes. Like Mr. Mukherjee had summed up in a date chart along with those references and the shortest possible submissions.
Possible.
Yes. Because you will be elaborating on those aspects while in your oral submissions.
Right.
IA number 8 of 2020, order number 8 रे जहाँ चीज़ सिर्फ पूरा लिख ले, cost title लिख ले, appearance लिख ले. Then IA 8, 11, 16, 15, they were taken up together. In terms of the earlier order dated 30th of April 2025, the matter was placed before Honorable the Chief Justice. For nomination of appropriate bench to take up the IAs 8 of 2025, IA number 11 of 2025, IA number 16 of 2025, and IA number 15 of 2025 arising out of the ADMLS. Stop. As per the endorsement of Honorable the Chief Justice dated 1/5/2025, the matter is assigned and listed before this bench. Hard Learned Senior Counsel, Mr. D.P. Nanda. instructed by Mr. Sambit Mahanti. Mr. Sambit Mahanti and Anurag Patti for the plaintiffs. The Lord Senior Counsel refers to the paragraphs 15, 16, 17, 18, and 23 of the plaint to submit that the amendment sought for will not change the nature and character of the suit inasmuch as the relief sought for remains to be injunctive and declaratory. In the amendment, by the proposed amendment, the plaintiff seeks to enforce his right for securing his claim
and indemnification
for securing an indemnification of his claim in the suit pending at
arbitration and
suit pending at Gujarat. Suit pending before the Gujarat High Court
and
as well as the arbitration proceeding.
No, that is not there. That is not there in the amendment application. It is, I will show your lordship the pair in the amendment. It's only in aid of Gujarat.
Okay. But anyway, it is a summation. Since it is attributable to their summation only, it's not a question of, I mean, the court holding it. I'm just recording his submissions.
Yes.
The arbitral proceeding initiated or yet to be initiated?
Already.
Initiated at Singapore.
Yes.
So that is how it is described, international commercial arbitration, or what is that?
Yes. International commercial arbitration in Singapore.
Initiated on sentence. Arbitral, the international commercial arbitration or arbitral proceeding initiated at Singapore. The Lord Senior Counsel relies on the decision rendered by the Bombay High Court, full bench, in JS Ocean Liner LLC, पूरा cost title लिखिए versus MB Golden Progress. Decided on 25/1/2007 in Admiralty suit number 11 of 2005. Paragraphs 2, 3, 30, 35, 36, 45, 48, 55, 56, 57, 60, 61, 64, 68, 72, 73, 77, and 78 are relied on. Referring to the conclusions of the full bench of 3 judges of the said High Court, at paragraph 78 of SEC online, but SEC online addition ऊपर दे देबे पार्टीना लिखला परे colon 2007 SEC online BOM 69, then colon दिख लिखंतु 2007 AI All India High Court cases AIHC all capital 1933 1933 into bracket full bench. Mr. Pati, while dictate, Mr. Nanda, anything I miss, you just kindly don't hesitate to tell me.
No, absolutely.
The conclusions, the last time. Now, which is reproduced here? The next is alter suber.
Yes, single bench. And the division.
Thereafter, the next decision relied on is of the Bombay High Court, reported in 2018 SEC 2730, rendered by a single judge in alter suber. Citation
that would be, my lord, CM offshore.
I'm sorry. Alter suber applicant, why it is mentioned that way in Bombay High Court? CM offshore. CM offshore, SIEM, S capital, space offshore, O capital, OFFSHORE, Redry, AS versus Altus Uber.
2018 SEC.
2018 SEC, that I think I have dictated. 2018 SEC online, Bombay 2730.
And upheld by the division bench, which I have not read out, but I can give the citation subject to.
The senior counsel refers to paragraphs 2, 3, 4, and 5 of this report to buttress his submissions. You refer to any other paragraphs there?
Just one. Yes.
66, 67 conclusion.
Yes.
Particularly the conclusion, the learned senior counsel then refers to the conclusions of the court.
Lord, apart from that, para 35 and 39, 40.
Paragraphs 35, 39.
$52,
52, 53, 54.
53,
52 to TO2, 54. Sorry, 52, 53, 54. Up to that goes up to 52, TO2, 56.
Yes, ma'am. Then, my lord,
paragraph 66 and 67 relied on by the senior counsel are reproduced here. 66, 67. Operator SEC online to direct भी नहीं पड़ी. ना अच्छी अपने SEC online.
From 66
the judgment in
66 to 69.
66 to 69.
Yes, 66 to 69.
Because I'm only referring to the paragraphs, but the main thrust only I'm reproducing.
Yes, that is.
We submitted that CM offshore has followed the earlier decision of the full bench.
That is after the 2017 Act came, because the full bench decision
after
was
the 2017 Act came into effect, came into force. Thereafter is Cuddalore.
Yes, only para 30.
The learned senior counsel refers to, relies on the observations of the Supreme Court in Cuddalore Power Gen versus Chemplast, Cuddalore, Vinyls Limited. Cuddalore Powergen Corporation. What should I देखिए no difficult. Versus Chemplast, Cuddalore, Vinyls Limited. Colon 2025 SSC Online SC 82. The senior counsel referred to Cuddalore, Supra, regarding scope of Order 2, Rule 2 of the CPC. He relied on paragraphs 34 and 38. 34 and 38 reproduce कर दे. The senior counsel for the referred to the decision rendered by the Supreme Court in Life Insurance Corporation of India versus Sanjeev Builders, colon, into bracket 2022, bracket closed, 16 SEC 1, page 1. Since the senior counsel dealt with this judgment at length in view of the scope of court's power to allow amendments to pleadings. As available under Order 6, O.6, R.17 CPC. Also, O.2, R2 CPC. 71
The conclusion.
71 till the end. 71 आरंभ हुई सेटा 71 71.1 up to 71.11. Paucity of time intervenes for further hearing of the matter on consent list on
Tuesday,
6/5/2025. The matter shall retain its position in the cause list along with the other matters. এটা ଦଉଛନ୍ତି ତାକୁ ଟିକେ ଅଲଗା ବିଡା କରନ୍ତୁ ସେଟା ବହୁତ ମୋଟା ହେଇଯାଇଛି. ବହିଟାକୁ ଦେଇଦେବେ ଟେବୁଲ ଉପରେ. ଆପଣ ଆଣିଛନ୍ତି ଚେମ୍ବର 73. ଏଇଟା ଚେମ୍ବର ରିପ୍ଲେସ କରିଦେବେ ସେଟା ଏଠି ଦେଇଦେବେ. ପାସ୍ ଓଭର କିଛି ଅଛି? ଥ୍ୟାଙ୍କ ୟୁ.